May I please? Hello, I beg to mention item number 42 on behalf of MS A. Bujor Rahman.
Yes.
He has informed over me over telephone, my lord, he is not well, man. He has taken the consent of other side
21,
after 2 weeks, man.
42.
Obliged.
Please, your lordship.
Yes.
I beg to mention item number 47 with the
Yes.
consent of the opposite parties.
Yes.
So here I need to file instruction, your lordship.
Review petition. You are for whom?
I am for respondent number 7, Assam Higher Secondary Education Council.
You inform the other side.
Yes, yes, sir.
What's your name?
D. Borua.
You are sending council.
My senior is standing only NN Upadhyaya.
And Upadhyaya.
NN
For the higher secondary education council.
Council. Possibly it is not shown in the council list.
Okay, doesn't. D. Borua, council appearing on instruction of the N. Upadhyaya sending council. Higher secondary education council. Okay. Praise for some time to obtain instruction. Please after 2 weeks.
On Monday, maybe.
Please after a week. Yes, sir, you are there in this matter.
Lordship, kindly insert that.
Okay, we'll fix the date there. List on. Everything 30, 30.
May I please, your lord?
30. Published to reflect the name of N. Upadhyaya, sending council, higher secondary education council. HS.
May I please, lord? I
Yes.
beg to mention item number 57, lordship. In this case, during the course of the day, we will file our affidavit, lordship. And the council for the petitioner also file justice service, lordship. Justice affidavit, lordship. Lordship, adjourn the matter for a week.
Sharma.
My lord, we will be filing an affidavit of service today. So, my lord, after a week, my lord,
Learned counsel for learned counsel appearing for the contesting parties informed this court has apprised this court that affidavit would be filed during court sitting. This after a week, along with the affidavit which may be filed.
obliged. Much.
No interim order pending.
No.
May I praise the Lordship? Lordship,
Yes.
with the consent of the other side, I beg to mention item number 55.
55.
Lordship.
Yes.
Lordship, they have filed their affidavit in opposition on Wednesday, 23rd. So I pray for 3 weeks time to file a reply.
PWD have you informed
We have taken the consent. Lordship.
on the prayer of the age of report learned counsel for the petition matter stand adjourned by 2 weeks
Lordship,
to enable filing of rejoinder report.
obliged.
May I please, your lordship?
Yes.
Lordship, for item number 7, your lordship, Mr.
Yes.
N.J. Khatuniar is on leave, your lordship. He'll be appearing, your
Is
lordship.
the standing counsel education
Lordship,
have
lordship.
you informed the other side
Lordship, I have informed.
on a prayer made on behalf of N.J. Khatuniar standing counsel
Secondary,
secondary education matters stand adjourned by a week.
lordship, on Wednesday.
Matters adjourned will be listed on Wednesday.
Obliged.
Please, my lord. My lord, item number 38, my lord. We are filing our affidavit today, my lord. I may be allowed to bring that in record. Obliged, ma'am.
You for the petition.
No, my lord. I'm for the respondent, Assam Urban Water Sewage Board, my lord.
Who is for the other side?
Sorry, my lord.
38 is a part of 37.
Yes, my lord. It's a serious matter, my lord. Some aspect has to be clear from our side, my lord.
You bring it.
Yes, obliged.
Your Lordship, I beg to mention for listing of a testamentary appeal. The case was
Presently we have been given bench for bench.
Okay.
Not yet.
May I please, your lordship? I beg to mention item number 32, my lord.
Yes.
I have taken consent to the other side, my lord. The matter may be listed after with me.
You for whom?
I am for the writ petition only.
I is by whom?
I is, my lord, as it is appeared, my lord.
Have you informed them?
He is present.
You for the you for the applicant.
Madam.
Come forward. Come. On a prayer made on behalf of opposite party, writ petitioner, matter is adjourned to be listed when?
After with me.
After.
Obliged me.
Is there any interim order?
Interim order, my lord, in my application, my lord.
There is an interim order. which
Interim
needs to
order
be
in my
extended.
application, my lord.
Interim order passed by the
shall continue.
Obliged.
Obliged.
There is a stay vacating application. You should pray for an extension. Otherwise, they will get vacated.
Madam.
You are praying for adjournment.
Obliged.
Next.
May I please, my lord, I beg to mention item before you.
54.
With the consent of, we have taken the consent of the other side also.
21,
After 2 weeks, your
2 weeks.
Yes.
On a prayer made by S0,
Yes, sir.
when it conflict for the petitioner, matter is returned, will listed after 2 weeks. Yes.
May I
Deeply
please, I beg to mention for Uddal Lordship, for contempt matter. First matter I'm taking Monday Lordship. Lordship, another matter is listing Lordship. First matter I'm taking Wednesday Lordship.
Listing
Pensionary
of what?
benefit.
Listing of petition.
Yes,
Re-
Lordship.
Matter which year?
Lordship 2023 Lordship. Pensionary benefit Lordship.
On Wednesday.
Obliged.
May I please? Not I beg to mention for listing of a case matter relating to pensionary benefit.
Pensionary benefit.
Yes.
What is the stage?
Not admission.
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 Next week in it.
Sure.
Don't give Monday.
Another payer or
Uh.
that is also listing of the
What matter?
lordship for promotion law. Junior to him
Matter of which year?
lordship present year 23.
Where are you mentioning? When was the last listed?
Last lordship directed to the respondent authority.
When was it last? What was the date of
Last lordship 5/6/2023 lord.
5 6?
Again take motion stage.
It's at the motion stage.
Yes.
On Friday. Who is on the other side?
Lordship
Which department?
lordship
Any affidavit filed?
administrative.
Any affidavit filed by now?
No. Directed to obtain instruction. lordship.
Friday night. Yes.
Lordship, review petition was fixed for today, but it is not listed today. Kindly allow for Tuesday, Lordship.
The file is not before us. We will not be able to pass order. You filed a mention memo.
I filed the mention.
You give a mention memo immediately. We'll get it.
Okay, Lordship. Obliged.
After the photo. How do you know it was fixed for today?
That is on record, Lordship.
Oh,
Date was given.
Date was given.
Yes. Yes.
Review 83 at 20. Review. Who's for the other side? P. Chakraborty. P. Chakraborty.
Yes, sir.
You please bring him to the court. We can fix it on Monday. If a date was given, why is it not fixed? We'll inform him so that we can pick up the matter on Monday or whichever. He may come in, but inform him. We'll also. Okay. Have to come back.
Maybe I beg to mention in IA for implement party, it was 521-8. Next week.
21-8.
Yes. Hello.
Next Wednesday for improvement of parties.
Yes, my lord.
Next Wednesday.
2020 met.
Maybe you Lordship. Lordship, I'm praying for upgradation of item number 56 plus appeal. Lordship, I heard the matter yesterday, Lordship, and fixed today for disposal.
Admission will bring. Don't worry. Why do you need upgradation? How many motions are there?
Lordship, 43 items are there.
Little bit. Don't worry.
May I please your lordship? Lordship, I beg to mention one MFA for listing in hearing, my lord.
MFA is not before this bench today. You have to go for bench, civil bench one. Give the bench.
May I please? I want to withdraw with liberty, my lord.
Who's the people? Talk about it for
Deputy Commissioner.
you're the state council.
State Council.
And for person number 1, Standing Council Revenue.
And who's for R5? Name deputy P. Roman. Under the council for petition. Submit that he has instructed not to press the petition. Also heard a approval and
Yes, Doctor.
as Dr. Leonard Standing Council for
Revenue.
Standing Council Revenue for petition according to discuss on with purpose.
With liberty, my lord.
Complied with
Lordship. As per the last meeting, Lordship, 9/8/2023. As per my
3 AMS
Majumdar.
Mazumdar Standing Council for petition submit that
Meeting
the
held on
order dated 24/6/2022 passed in WP 4188 of 2022, which is the subject matter of contemplation has been complied with. He accordingly submit that do not like continue with contempt. Considering the above, the present petition is closed.
My lord, in this case, Lordship, in my petition, they filed my reply, Lordship. I want to file rejoinder, Lordship. I pray for 3 weeks' time, Lordship.
And Madam,
Lordship, we received a reply, but it's not a reply to our writ petition. So they wish to file a reply to our writ petition because we've been
no,
served
is
this.
the issue common?
Lordship, facts are a little different because
No,
Mr. Parriwai-
if they say that the issue has been covered by one of the counter, then you might find a rejoinder in the common stating that we are common affidavit of.
Doctor, there are factual averments which if they don't choose to deny, then it's
Yes,
admitted.
yes, what is the bottom?
Prayer is almost same, my lord. Prayer.
No, it's up to you. We are nobody
Yes,
to advise you.
exactly. Yeah.
If you think that your affidavit filed in Mr. Mazumdar's case covered all the cases, then it's your call. You can accept that. But if you think that you're required to file affidavit separate, then it's up to you. And what Madam Kusam is saying that facts are slightly different. Unless there is a specific denial, then it's up to you.
There are no specific denial regarding
Lordship.
So then, my lord, if time may be granted, we will file our affidavit. In the meantime, my lord,
But no, not really. If you think that the law point is the same,
my lord, law
file it soon. And by the time Mr. Muttar will file the rejoinder,
Lordship, I pray for 3 weeks' time, Lordship.
no, we'll give you 3 weeks.
Lord.
They
Well,
can file it
if-
within a week or two. Thereafter, you will get also.
1 week.
It appears that the department has filed an affidavit in opposition in WPC 7092 of 2020.
Lordship.
Sri Bora, the Standing Council, however, submit that a separate affidavit in the other 2 writ petitions may be required. At the same time, Sri Mazumdar, K. Mazumdar, Council for Petitioners, WP 709 2020, submit that you would like to file a rejoinder. List of the 3 weeks, by which time affidavit may be exchanged. Is there any interim protection?
Lordship, earlier interim order may kindly continue.
Can be vacated?
I pray, Lordship.
For vacation, you need not say kindly. Interim order passed that day. Then the extended till the next date. We fix the date.
Lordship,
Is there top of the list matters, assigned matters? Mr. Bora,
my lord,
have a date of your
26 September. My lord,
Lordship. Our item
Why we have passed the same order? Connected, isn't it?
26.
Some of the just give us a date of your choice.
26.
Yes. On
26 September.
26.
26 September, my lord.
Is it okay for you?
Lordship, please.
26 is what? Tuesday, okay? Tuesday, no, don't Tuesday. Perhaps
Then
you might need some time for filing return.
Lordship.
Have you done a motion?
27,
25th?
my lord.
25th.
Obliged.
We have not.
Hmm?
My lord, same order will follow, my lord.
Same order, because he has filed affidavit in one. If you want
My
to
lord.
file affidavit in others, he can. On 25th next week.
My lord.
May I please, your lordship?
Yes, what is this?
My lord, matter pertains to my lord provincialization of service of the petitioners. My lord. And the because of a false complaint, my lord, lodged by one of the my lord, Hindi teacher of the school, my lord. The school was not provincialized, although the my lord, the district scrutiny committee, my lord, they forward the list of the teachers, my lord, before the concerned authority. And my lord will
Just-
kindly have a
just-
look.
I mean, what is the problem? Yes, yes,
My
My
lord,
lord.
here, my lord,
yes.
we
You
have
got the
written
instruction.
instruction, my lord. Here, my lord, I have, my lord, forwarded that copy, my lord.
Yes.
Here, my lord, uh, oh, my lord, district-wise breakup for newly provincialized school, which both, my lord, I have forwarded. Here, we have received the instruction. Regarding, my lord, you guys, my lord, that will have to provide it by SSM.
SSA is see, notice matter is in the top of the list is 23 matter.
My lord, true, my
And none of you have filed your affidavit.
lord. Right.
Yes, my
We'll grant you some time. You can put this instruction by way of an affidavit
My
on
lord,
record.
my lord.
He also gets the chance to rebut.
My
We grant you so much time. 2 weeks time? 2 weeks?
my lord.
Madam, I put the instructions or not? Then we have give 3 weeks, but we fix the date.
My lord. Lord, can it be on?
We get much council. You're supposed to find a report, submit a report. Have you done that?
My lord, this is
the
what I have
report.
received.
Also heard, but also heard PK Bora, sending council, I think State Department. Has submitted that
Yes.
written instructions have been received. A copy of which
My lord, we
Is
will
also-
file by way of an affidavit.
is also placed for this court. The written instructions also contain district-wide breakup of the village which was you have filed to submit that necessary instructions are also required based on record by SSA. The SSA is sent by PDAS, who is present. Both Sri Bora and MS Das, the learned sent on based on brief and are accordingly granted 3 weeks time to file affidavit in this case. There are at least on
My lord, can it be on 27th?
7
My lord.
Vinayak. Doesn't matter. Are you required to file any affidavit? No.
September.
He does.
Obliged.
My lord.
My lord, in this case, instruction was sought, my lord.
Otherwise, a very old, like it's a 2020, 2000, the person has died. Compassionate appointment, but nevertheless, the Honorable Court has asked for instructions, my lord.
Whether her case was ever placed before any DLC or not, my lord. So in fact, her case was never placed before any DLC. The last official communication is on Annexure F, my lord, page 17, my lord.
Did you actually apply on time?
Yes, my lord.
What is
Lordship,
your instruction?
the instruction is that we have got partial instruction also from we have got from Dhemaji. They have said that we have sent the matter to the Deputy Commissioner Sivsagar for placing it before the Sivsagar DLC. Your Lordship.
When was it?
That was sent on 2007. However, subsequently from DC Sivsagar, we are yet to get the instruction. Lordship. SP Sivsagar has said that they are trying to track up the matter because it's such an old matter. Your Lordship. But
No, we are really concerned with
whether it has been
whether the application was given on time.
Yes,
If
my lord.
if the death is of the year 2000,
Lordship.
if we apply after 7 years,
Lordship.
then it's of the scale matter. There is no objective to be achieved
Lordship.
by way of completion requirement.
Lordship,
But
yes.
My
what
lord,
has been averred in the petition is the death was in February and in May the application was made.
Lord.
So that is the case, then at least there has to be a fair consideration.
Lordship, yes.
Whether he gets or not, that's a different thing. But the right to have a consideration is there.
So that's what your Lordship, the Dhemaji has sent it to Sivsagar. Now, whether it from 2007 also, whether
Why
the DLC,
was it sent to Sivsagar?
Lordship, possibly because
my husband was working in Sivsagar
she placed it before Dhemaji, I believe, your Lordship.
and he's a resident of Dhemaji,
But the place of posting was at Sivsagar.
Sivsagar at the time of death.
So it will be considered by the Sivsagar.
So the only thing, whether it has been done at least once and whether it was on time, that two things are required, your Lord.
To get the instruction.
I've already telephonically asked them. They said that they got it very late, so that's why they're taking some time.
MS has been chosen counsel for the petitioner, whereas the CS, you write F,
CS Hazarika.
whereas CS permanent is present for this. Sarah, the government has submitted that partial instructions have been received. Instructions have been as per the matter regarding appointment on competition ground was forwarded from Dhemaji to Sivsagar in view of the fact that the deceased government servant was serving as the district council, however, praised for some time to have complete instruction as to whether the case of the petition was considered a crime. Yes. Then
First, 2 weeks time, your Lord. They're taking.
list of as witnesses, list of
My lord, the date may be fixed, otherwise.
Tell us, madam. Tell us what it.
My lord, next Monday, my lord.
We said 2 weeks. Today is what? Today is 25th.
8th, your Lord, exactly 2 weeks.
Yes, my lord, please.
On 11th.
Obliged.
Yes, what is this?
Right. Well, this is regarding appointment of public prosecutor in the district of Dhubri.
Public prosecutor.
Public prosecutor. Earlier matter was listed. Government advocate was directed to obtain instruction.
Madam, the allegation of the petitioner was.
Oh, just a minute.
My lord.
What are your grounds?
I have filed this petition on 2 grounds. First, my lord, the district magistrate issued a notification.
What is the provision of law for appointment of public?
24, my lord, section 24. CRPC. Subsection 4 is relevant, my lord. 4 and 5.
Come to 24.
24, 4 and 5 is relevant. 4, may I read, ma'am?
Now, first, We'll read 24, but what are your facts? Tell us.
24,
Now, what are your facts?
fact, my lord, the
How
district,
many petitioners are there?
only one. Only one post, one petition. The district
In which
magistrate,
court?
my
In
lord,
which court?
your lordship will find page 17.
Which court?
Dubri,
To be what? Or which court?
district and session judge Dubri.
Sessions
Sessions Court Dubri. By issuing, my lord, notice dated 3/11/21.
Yes.
That is at page 17 I have.
17.
Yes.
Yes.
The LR and Commander Secretary, Government of Assam Judicial Department asks all the district magistrate to prepare a panel in consultation with the concerned session judge.
Yes.
Hereafter, page 19, the district magistrate Dubri issued notification asking the interested advocates to appear in a walk-in interview. Page 19. I have got it.
Page
19. 19.
19.
Here for interview of public for the post of public prosecutor, date is fixed on 2nd February 2020.
Page 122.
2nd February.
No. See this notice was 28/1.
Yes.
Notice
28
by the district magistrate.
Fixed for the post of public prosecutor, 2nd February 2020. Now page 20, my lord. My first submission on the basis of page 20. That seems by 28/1 letter notification, district magistrate called for walk-in interview to come up. The respondent, private respondent who was appointed, he did not appear in the interview. Because page 20,
Respond number.
private respondent
Number.
5. Page 20. This is a attendance who were appeared in the interview.
5 is the person who has been appointed.
Appointed.
He did not attend the interview.
He did not be. Only here, your lordship will find 5 people assigned. 5 advocates. Their signature of the 5 advocates. My signature is at serial number 3. So my first submission on the basis
Where
of
are you? What is your name?
page 3, serial number 3.
Your name is
Sudhaman Chandra Roy.
petitioner.
Yes. So my first submission is on the basis of 20. That since 21, he did not appear. So there is no merit list prepared at all. It is a political consideration appointment. And the second is, my lord, page 22. This is a panel.
Yeah.
This is a panel. In the panel, your lordship will find only one initial is there. As per Annexure 1, page 17, this district judge ought to have prepared this panel after due consultation with this concerned session judge.
District magistrate.
District magistrate. District magistrate are asked to prepare the panel after due consultation with the concerned session judge.
What is the name of the respondent number 5? Bandhu.
Yes.
Bandhuram.
Yes. No. Harmohan Das.
Number 2 here.
His name is there.
Number 2 at page 22.
Yes. My name also said as serial number 3.
Harmohan Das is respondent number 5.
Yes. Sir.
Okay.
So on the basis of these two issues, my lord, I have raised. First, he was not, the private respondent was not appeared in the interview, so there was no appointment on merit. And next, the panel was, my lord, not prepared in terms of notice at page 17. The district judge concerned session judge was not taken into consideration. Your lordship will find last page of page 17, last line of page 17. With due consultation with the concerned district and session judge. So that was not done.
Yes, how do you, what's the basis of your submission that it was not consulted?
Because I have page 22, because had it been done with due consultation with the session judge, the signature of both session judge and district.
No, that will be appearing in the files of the file movement. But the main, these signatures may not appear. But your first submission is that he was never there in the interview. That is a substantive submission.
Yes.
And here we need to see the records whether the session judge was
Whether merit list is
consulted,
prepared, whether it is on the basis of merit or not.
whether it was whether he was consulted. These
Yes.
are your two submissions.
These two. Yeah.
Yes. So Mazumdar, you are appearing.
Well, I've given the various comments that have come.
Yes.
The submissions are twofold. One, there was no consultation.
Yes.
And Lordship may kindly see page 24.
24
My lord.
of this petition.
My lord.
Yes.
Page 24 is the letter from the deputy commissioner to the LR.
Hmm.
The body of the letter I'm reading, my lord. With reference to the subject, there is
Discussions were held with,
my lord.
I read this.
I have the honor to inform you that in pursuance of the letter under reference, discussions were held with district and session judge. And he is not disputing this. He is simply saying that there was no dispute. And secondly, my lord,
Just a minute. Letter by DM to LR. Okay.
now second
Anyone
part,
appearing for the Guwahati High Court? Is district judge made a party? Judge?
No.
Why?
Because
If
I have no
you-
any grievance against district judge.
Not a question of grievance.
district judge is a party, my lord. That's number
Party
three.
is. Oh, yes, yes, yes.
That's
He is a
number
party.
three.
You don't even know who is the party.
I am sorry, but he is a party.
Anyone appearing?
Yes, district judge is a
Possibly
party.
the Bosley's notice has not gone, my lord, till now.
No, we'll hear you, but we'd like to have the views of the district judge. Obviously, of course, this letter makes it explicit that there was a discussion. We'd like to have his views also.
Right.
But Prime Minister, we are going by what appearing in this letter.
And
No,
my lord, second contention was that
did they attend
walk-in
this?
interview, he didn't appear. My lord, I've got two full submission on that. Lordship may kindly turn to page 21.
2-1.
My lord.
Yes.
According to my instruction, my lord, this is not part of the record. No such attendance sheet was prepared.
What is 21?
21 is the
Signature.
document, my lord, on the basis of which the petitioner is saying
What is this? It's the photograph.
Attendance sheet.
photocopy and
What?
of the, according to them, it is an attendance sheet where the respondent number 5 who was appointed, his name is, his signature
No,
is
who
not
has
here.
vouched this?
And that is what I'm saying. In the, I've seen the paragraph, it will be verified as a true to information based on record. No record has been produced. Nothing is mentioned in the paragraph also. Now, my instruction is, this is a document prepared possibly by the petitioner himself. It's a signature, all the signatures by one person. Same type of signature or kind. Not a part of the record. This document
Pictures of
is,
their-
all these signatures, all these names are mentioned by one person. So absolutely clear from this manner.
In that case, your lordship kindly examine the record, my lord.
No. Prime Minister, the part at page 20, which is a fair copy made by you.
Yeah.
Come to page 20.
It is a type copy, my lord.
Not let.
Huh.
20. What have you stated? Type copy of the attendance sheet
Hmm.
showing the signature
Hmm.
of the advocates who appeared in the interview. We have not shown showing the names that somebody had jotted down the name in the official record, and this is you have termed it a signature. If you turn over the page at page 21, these are by one person. only. It cannot be
So
signatures
this
of,
document is supplied by the office of the district magistrate.
no, it is a document which you have produced in the court.
Yeah.
You take responsibility. And this part, which you have made a part of the document at page 20, this is not a part of the thing. This becomes a part of the document.
My lord, if your lordship examine the record, my lord,
When
relevant,
was the this made appointment made?
because appointment made, my lord, on 1/6/23,
First
On-
June 20,
Where is the order of
page 25.
page 25.
The very second paragraph is The respondent number 5 name is what?
Page 25.
Page 25, second paragraph.
And the instructions that we have received, my lord, I have supplied a copy of the same to your lordship, my lord.
Yes.
Last page, lordship will find there is signature of deputy commissioner as well as district judge.
The last page signature is there, that I have mentioned. Your lordship said, my lord, in Johri Lal case, what is the consultation? What is the consultation that has been defined? My lord is well aware. That must be effective one, my lord. We are putting a paper in the last paragraph signature, whether it is in fact effective consultation or not, my lord. Because my my submission before your lordship is that there is no effective consultation.
No, to support your
And notification itself says due
See,
consultation.
if you say that there was no effective consultation, the district judge has to come up and say that yes,
Yes,
I was
yes.
not consulted.
Yes.
He's not come up. He's not,
Learned advocate name is not shown.
but with this kind of instructions which learned age is produced for the court, do you think that litigation needs to be continued any further?
Yes, my lord.
That too in a
Because
post
the
of
saying of
CP,
district judge is necessary, my lord. Who?
that too in a post of prime officer, we find that the law has been adhered to. The district assessment judge has been consulted 24. Hawking thing is something which will not say manufacturer is your version, which is not supported by the records. And these are posts where distribution plays a major role. Unless
My
the
first-
distribution
Going
has
by
been
my first
exercised in
submission.
a malafide manner, so perhaps will not interfere.
What is the difficulty of my lord, my learned council that they are not producing the merit list? Is there any? Because if interview is at all called for, then there must be the merit list, my lord.
Merit list he has given.
This is a panel, not merit list, my lord. This is the name of panel. 3 name. My name is also there. This is the panel.
How do you ultimately select?
My lord,
How do you ultimately select?
my lord, this is the
You have given a chart.
yes.
Contains 3 names: Bandhuram, Harmohan,
No.
and Sudhaman Roy.
Yes.
Sudhaman is the petitioner, Harmohan is the
Respond.
beneficiary.
Right.
Now we have chosen the panel number 2.
My lord.
Yeah.
What is the basis?
It's done by the deputy district magistrate after consultation with the district judge.
Ultimately, how is selection?
No formal interview is necessary, my lord.
No, understood.
Right.
But out of the 3,
My lord.
one has been selected.
Yes.
Let us accept what we have followed from you, that we have followed the law 24 has been adhered to consultation. But ultimately, you pick up, you choose someone. What is the basis?
Well, based on their performance in the court, the district judge is aware of the
Understood.
Sorry.
But is there has to be some discussion. Just out of A, B, and C, we selected for this reason.
let the district judge come up with the reply.
So ultimately, your call.
No, I have
District judge will only be, the session judge will only be consulted.
this panel was forwarded. This panel of names were forwarded by the deputy commissioner, which was countersigned by the district session.
No, that is okay. Consultation part you have done.
Right.
But ultimately, who is the appointing authority? It is you. Your appointment has to be based on certain reasons,
Right.
which probably would be not probably, which has to be in the fight.
Right.
These reasons may not be a part of the appointment order. Have you got the record?
Record.
Get the records in the meantime. We'll also. Otherwise, we're not too much interested in making a roving kind of an inquiry in these matters,
I think
where we find prior FSI compliance.
with this comment, the pairwise comment that we have received, we can file an affidavit also. The lordship directly.
Get the record. I would Senate counsel for the petitioner, whereas the state is represented by the learned additional advocate general Sri D. Mazumdar, senior counsel, who is assisted by the are for state council. Has notice been issued?
No.
No, not yet.
Will issue notice that
Yes.
the revamp of the petitioner is with regard to
No, not that.
a notification date 1/6/2020, whereby the respondent number
Right.
6/5
5.
has been appointed as the public prosecutor in the court of Session Judge,
District and section.
District and Session Judge, Dhubri. Sarah. This court, while considering the matter on 11/8/2023, has recorded the principal grounds of health, which are twofold, namely that the respondent number 5 did not attend walk-in interview, and second, there was no consultation with the learned test judge as required under section 20 of their the Mazumdar, the learned AAG, has produced instructions today, and by referring to the common, he has submitted that both the grounds projected are incorrect. He submits that there is no official record of any attendance, and a prime minister look at the document thought to be relied on by the petition does not appear to be the signature of the intending of the aspiring candidate. He has also referred to a communication dated 17/2/2020, which is a part of writ petition, from which it clearly appears that there was a discussion with the learned test judge as required under section 20 of their thereof. The aforesaid instructions are required to prime minister from this court of the opinion that the ground taken in this writ cannot be sustainable, to give a fair opportunity to the contesting party. The person of the learned district and session judge who has been arraigned as respondent number 3 is also required. Sarah, that notice is written on
3rd week of
18th of September. 18th of September. The respondent numbers 1, 2, 3, 1 to 4 are already represented. No press steps are required to take. However, state respondent may file the affidavit based on the instruction by that step be taken for service of notice upon the respondent by through the Learned Standing Council, Guwahati High Court, who may be served and an extra copy of the petition. So far as the total file is concerned, steps are required to be taken by registered post within 3 days. 3 days.
Record, my lord.
On the next day, we are heard. Then government advocate, eternity, shall also produce record. This is not
Registry may direct to show the name of it, High Court Council.
the name of that council. Guwahati High Court.
I am like.
Sir, वो copy today is
My.
My lord, instead of 18, let it be 27. Let it 1 month go in the meantime. 27th of September.
18 to 27. What?
No, I'm saying instead of 18, let it 6 and 27.
No, what was the reason?
I said that we will have enough time to.
Oh. 27.
Oblige.
May it please your lordship. My lord, your lordship may be please see page 68 of the petition, madam. It's the compensatory appointment.
Balance 3 years judgment is there, doctor. The balance 3 years, it was the DLC held in, case was rejected because of the less than 3 years.
And retapel decided.
No, your lordship. This is the last order, nothing, no specific stay or decision.
We issue notice. And
Lordship.
Okay. Part the MH transport account for time has raised the cost of not consideration of the case of the for appointment on compassionate ground. It is the protected case that the who passed away, that the father of the petition was a forest guard and had died in harness. However, the rejection of the case of the petition is on account of not meeting the minimum balance period as would appear from resolution dated 28 to 2019.
May I interrupt once? I'm very sorry, your lord. First, here the party, the commissioner, the SLC is being represented by the commissioner secretary, personnel B department. It should be the chief secretary. Then I have to file it. Page number 5, your lord.
Care of this is not proper. The head of the state level C.S. Hazarika, that is state of has, however, informed the court that issue involved is subject matter in a writ appeal before the Honorable Division Bench, being WA 287 of the which is pending considered that written by Corey. That step to take it. No, the 3 years of the 3 years of the granted state of Texas on behalf of on and to take notice What here for on behalf of
Respondent
no. Who is this thing?
PN.
Council appearing on instruction of PN to serve understanding council for his department except this on behalf of that extra copy of the served upon the learned council within 3 days.
I have already started office.
Already served?
Yes.
Forest department has served?
Yes,
One. No, Your Lordship, that we did
forest department.
advance copy may have been served, but
Oh, you talk about just that need to serve one copy.
Obliged, madam.
May please your lordship. Regarding the Swatantrata Sainik pension, after death of father of the petitioner, mother was getting Swatantrata Sainik pension from both state and central. After death of her mother in 2005, the unmarried daughter, that is petitioner, is entitled for the same. The state government has already given pension from the death of her mother, but the central government has been passed an order and allowed pension with effect from 1/9/2015.
What is your response now?
Lordship, I am seeking arrear pension from 3/12/2005. On that day, my mother was expired, but central government has given pension with effect from 1/9/2015.
Where is the order?
Lordship, page number 24.
4.
Yes.
Yes.
Operative para number 2. Last 2 lines.
Yes, who is appearing for the
I'm appealing for the state government.
central government?
PN 5 Lordship.
Central government.
Central government is the main part.
Have you served on the city?
I have solved.
Name,
There is
name
no-
the two or not?
Yeah.
And if yes, who
No, no, Lord.
anyone, any central government council? The government would, who can issue notices? Whoever would come will have it. How free as government can come for petition. So, the grievance raised in this petition is with regard to the fixation of date from which the pension under the Swatantrata Sainik Samman scheme has been granted to the petition. It is the projected case of the petition that her father was a freedom fighter and was getting the and on his death, the mother of the petition was received pension under the effort scheme. However, the mother of the petition had also passed away on 2/12/2005, and the petitioner, being an unmarried and dependent daughter, was accordingly entitled to the family pension. However, so far as pension under state scheme by the central government is concerned, by the issued letter dated 31/5/2022, such pension has been granted only from 1/9/2015, which has been changed with the date of the application. The petitioner's claim is that he is entitled to the ADR pension from 3/12/2005. That is, i.e., immediately on the passing away of her mother. A parent to notice returnable by 3. Yes,
1 and 2.
as destroyed under this access notice on behalf of responsible 1 and 2. Chakraborty,
3 and 5, Lord.
3A Chakraborty, State Council, 3 and 5. AG R. K. Talukdar, for responsible 4. That extra copy. Within 3. Yes.
Obliged.
May please.
Item number
12.
My lord, I am appearing for the caveat.
12.
caveat. What is that?
Well, it's regarding appointment of a Kaji, my lord. Here the petitioner
He is the beneficiary.
no, my lord, I was appointed
He
as
is the beneficiary.
Yes.
Caveat.
What happened, my lord?
No, first let us discuss
Yes,
caveat.
yes.
SM Rahman.
Am I okay?
Your MI Hussain. Third is MI Hussain. That counsel for the caveat who has lost this caveat with regard to an order dated 21/6/2020 passed by the district registrar and deputy commissioner Nagaon, whereby caveat has been allowed to perform as the marriage and divorce as the Qazi.
Yes.
As the Qazi.
MMR and
Perform as MMR and Qazi under Laufa Sapuri Police Station. In addition to his own jurisdiction, the caveat will be heard in the event the court proposes to pass any interim order. Caveat activate then third. Yes.
My lord. My lord, I was appointed, my lord, on my lord 29/8/2006, my lord, that your lordship will find at page 18, my lord, 18, my lord.
As what?
At Kazi, my lord.
29?
29/08/2006, my lord.
Appointed as Qazi.
Kazi, my lord. For the entire Kuliabar subdivision.
Okay.
Now your lordship may turn to page 7, my lord. Or otherwise, my lord, I will apply.
Doesn't matter.
Page 7, my lord. 7, my lord. The section I have incorporated, my lord. Page 7, my lord, paragraph 8, my lord.
Yes.
As per the, my lord, Assam Muslim Marriage and Divorce Registration Act 1935, my lord, section 3 provides, my lord, the state government may grant a license to any person being a Muslim, authorizing him to register Muslim marriage and divorce, which has been effected within certain specified limit on application being made for such registration and may revoke such license, my lord. Now, this proviso is, my lord, very important, my lord. Provided that not more than 2 persons shall be licensed to act within the same limits, and provided further that when 2 persons are so licensed to act within the same limit, one should be a member of the Sunni and other of the Shia sect. So here in the instant case, my lord, the petitioner belongs to Sunni, my lord. He is already there, my lord.
and he is performing his duties. And now the order which is impugned, my lord, at page 19, my lord, 19, my lord, the caveator, my lord. It does,
21-6.
yes, my lord, 2106. It does not specify, my lord, which sect, my lord, because I am a Sunni, I'm a Muslim, my Sunni belongs to Sunni sect, and I am performing that, my lord.
Have you made a statement that he also belongs to the Sunni sect?
No, my lord, I don't know what sect he belongs to.
Then-
Well, first of all, my lord, the order which has been passed on 21.
What is your who is your response number? Your if the act provides
Yes, my lord.
for a leeway that case he belongs to the other sect,
My lord.
then there can be another. And if you are not making a statement
My
that
lord.
both you and the response belongs to the same sect, either Shia or Sunni,
Yes, my lord.
then where is the foundation of it?
My lord, second, my lord, if that statement he has not made, my lord, to be honest, my lord, fair enough, my lord. My lord, second point.
No, we'll expect that from him.
My lord.
He might say that I belong to Sunni, that the bar may come.
Yes, my lord.
But to make out a prime case, you should have made this case.
My lord. Now,
Yes.
my lord, the second point, my lord, which I want to argue, my lord, that is, my lord, page 8, my lord.
Yes.
My lord, it is the Kaji Act, my lord. It says, my lord, a person, my lord, may I read out, my lord, paragraph 9, my lord. Wherever it appears to the state government that any considerable number of the Mohammedan resident in any local area desires that one or more Qazi should be appointed for such local area, the state government may think, if it thinks fit, after consulting the principal Mohammedan resident of such local area, select one or more fit person, appoint him to them Qazi for such local areas. Well, he should be a resident of this area, my lord. The present respondent number 6 doesn't belong to this area. My lord. He is a Qazi in the Juria already, my lord, already appointed as a Qazi, my lord.
No, where is the requirement?
My lord, it says, my lord, if it thinks fit, after consulting the principal Mohammedan resident of such local area, select one or more fit person and appoint him or them to be Qazi for such local area.
Yes.
But he is not a resident. He is not a resident of
Not
my.
required, not required. It is not the consultation has to be of the local.
Yes, my
resident.
lord.
The person is not necessary to be a local. We'll examine it.
My lord.
My lord,
Are you defending your case or damaging your by saying something?
Lordship,
Better not to say anything. Because we listen to note.
Lordship, my lord, the annexure, last annexure, Lordship, annexure 3, page 19.
19.
My lord, annexure already been, my lord, read out. Lordship.
Yes.
My lord, he is the person, the private respondent has already been appointed as a Qazi.
Yes.
My lord, he's, in addition, my lord, he has been given some process is going on, my lord. As per the, my lord, that order, Lordship. On
No,
the
we have noticed that he is not been appointed.
not
He's-
appointed.
he's
It's
been
the additional service.
No, we'll examine.
Well, the representation is given by the some of the local people. On the basis of that local people, some arrangement has been made.
Mr. Dotto may be very popular in the place, therefore.
And my lord, this is
additional
given in
arrangement
the
has been
my
done.
lord, that Kolliapur subdivision, lord. It is, my lord, not that, my lord. It should be the particular police station.
Yes.
Under the police, one police station,
Okay.
one, my lord,
I'd see- I'll get the-
MMR and Qazi can be appointed.
Okay.
These
I'd
are
say
also
there's a
government
learned
employee.
for the petition. The petitioner was appointed as a Qazi by an order dated 29/8/2006 for the Kolliapur subdivision. Full stop. The grievance of the petitioner is with regard to an order dated 21/6/2023 issued by District Registrar cum Deputy Commissioner Nagaon, by which the respondent number 6 has been authorized to perform marriages and divorce at Alpha Chapoli area. In addition to his own jurisdiction as Juria, the district of Nagaon. Full stop. petitioner has structured the grounds of challenge in a twofold manner. So firstly, it is contended that there is violation of Section 3 of the Act of 1935, Assam Marriage and Divorce Registration Act 1935. And secondly, he has also alleged violation of Section 2 of the Kaji. Am I under conflict for the responsible who has entered appearance on the strength of a caveat has, however, submitted that the response number 6 was already a Kazi and by the order which has impugned, only additional charge of an area under the Laupa Sapuri Prestige has been given to him, and the order does not suffer from any irregularity or illegal. Para 3. J. Henry Leonard State Council also submits that the order has been in accordance with law. For the para 3, that is from that is returnable 5. 6. 3. J. Henry Leonard State Council accepts on behalf of responsible 1 to 5.
1 to 3, Lord. My lord,
Five, 4, 5,
4, my lord, that post. I think
You can take.
Deputy Registrar Revenue, my lord, in Nagaon district, my lord, that
Why not? These are all government, deputy commissioner. Why not put in?
What?
For 1 to 5.
1 to 5.
1 to 5. That extra copy accept notice on behalf of
can I pray for a stay, my lord, of
the
because he is also already.
you might have to reject if you
Well,
first.
I'm obliged. my lord.
May I please, Your Lordship? Petitioner hearing, Your Lordship, was a contractual employee in the Department of PNID, Your Lordship. His service has been terminated, Your Lordship, without giving him an opportunity of care.
What? You're a contractual employee.
Contractual employee.
Tenure is over. Tenure is over.
But it was subsequent, no, Your Lordship. Subsequently, at the time of termination, he was in service, Your Lordship. And
What was the initial tenure?
Yes, Your Lordship.
What was the initial tenure of your
3 months, Your Lordship.
3 months?
Yes, Your Lordship. Subsequently, it was extended, Your Lordship.
How much time did you ultimately serve?
On 24 years. Your Lordship.
24 years.
24 years. This is a covered case, Your Lordship. This honorable court has already.
24 years is too long a time.
And Lordship kindly covered case, Your Lordship, on similar situated case.
Will you grant them some time?
contractual employee, Lordship.
P.K. Pira, Standard Council for petition, who is active by the action of terminating the services of the petitioner who was working as a Gram Rozgar Sahayak. It is submitted that to the initial appointment made in the year made on 30/9/2009 was is it 24 years?
Oh, sorry, Your
was for a particular tenure, the services were extended from time to time, and by this and and the petitioner has served for about 14 years.
14.
Full stop. No, this part is submitted that the due process of law was not followed before such term. And to notice returnable by 4 weeks. PNRT. Sending on Panchayat and Rural Development Department accepts notice on behalf of restaurant number numbers
1, 2, 5, 6, and 7.
5, 6, and 7, whereas each of report state council
PN4.
accepts notice on behalf of restaurant numbers 3 and 4. Para that council for the by within 3 days.
Public.
Yes.
My
this
husband
is
rendered
like
his
this.
services as constable in first APPN Legere Pukli Nazira in the district of Sibsagar. And after render his services almost 8 years, 10 days lordship, he was suffering FIO disorder, that is a mental disorder, your lordship. Subsequently, he died on 22/9/2019. After death of my husband, I initially approached Tripura authority for granting pensionary benefit lordship. But lordship, initial stage same has been rejected lordship. As aggrieved the same, I have again filed. I have filed WPC number 1788/23, and same has been pending. But in the meantime, lordship, authority let me know that my husband got voluntarily retired, lord. That is on 36/2019, lordship. And lordship, so communication letter dated 3/4/2023, lordship, Annexure G, page number 47, lord. Kindly be pleased.
What is 15/5/2023?
Lordship.
What is this impugned order of 15/5?
Lordship, same order has not furnished to me. That let me know that my husband got voluntarily retired. That is as a result 36/2018.
Yes. Then it counts for the petition. It's contended that the husband of the petition, who was serving as a constable in the first APPN, Legere Pukli Nazira, had died on 22/9/2009 after entering service of about 8 years 10 days and was not getting pensionary benefit. The petitioner had earlier filed WPC 1788 of 2020 with a prayer for such pensionary benefit. Thereafter, by a letter dated 3/4/2020, the petitioner came to know that her husband had got voluntary return on 36/2018. The result of the petition is that such information is not correct,
Yes.
as at no point of time her husband had got voluntary return during his service. And that notice returnable by 4 weeks. Yes, Mr. Hazarika.
And for response number 1,
3C S.
4, 5,
Hazarika, United States Council
No,
accept
1,
on favor of 1,
3,
1,
5, and
3, 5 and 6. Finance.
No.
R. Mazumdar, R. Borpujari, Turning Council Finance for 2 and 2. Mr. Talukdar
For 3, my lord.
and
4, 5.
for response number 3 AG.
I'm sorry to say I am for 1, 4, 5, and
Color covered.
all are
Let extra served.
Hello.
Within 3 days.
May please, your lordship, matter related to the appointment selection and appointment of Anganwadi helper, my lord. Number 101, number Kulabanda, Maspara, Anganwadi Center under Gomapalpuri ICTS Portal in the Bavada district, my lord. The respondent authority advertisement dated
Student
30.
cannot be a helper.
Helper.
Student cannot be a helper.
Hello?
A student cannot be appointed
No,
as a helper.
no,
That is your
the regular student cannot be appointed.
that is the
As per
that is your principal ground of challenge.
yes.
Third, we answer it. I may answer when it comes for the petitioner who is aggrieved by the appointment of the respondent number 4 as Anganwadi helper in the 101 number Kola Bandha Maspara Anganwadi Center in the district of Borpeta. The principal ground of challenge is that the state respondent number 4 is a regular student and there is a bar for appointment of regular student as Anganwadi helper. That notice returnable for for 1, 2, 3. Extra copy. 4 extra.
The date may be fixed.
This on
9.
You have it on 18th of September.
Oh.
This one.
May please, your lordship. As per advertisement dated 4/10/2017, I had applied for the post of medical record officer. And accordingly, I had appeared in the written test and passed the written test. Thereafter, the respondent authority issued a notice asking to appear before the respondent authority for verification of.
Let us see the speaking order 28/7.
Yes, lordship. 45.
45.
Yes, lordship.
First, let us see the order of this court. 44.
Initially, this honorable court had directed to consider the case. Thereafter, I have.
Page 35. Okay. There is direction for consideration.
Yes.
You had considered
Yes, my lord.
Okay.
In fact, at page 45, the speaking order has been passed.
Let us see.
Lord, you will see, my lord, the last third paragraph. The petitioner herein, my lord, does not have the requisite qualification as prescribed by in the advertisement. And Lord, you will find the qualification at page 20. Last third paragraph. Page 22 is the advertisement.
Yes.
Graduation here for, but with medical record officer training from recognized institute. This melody is like, and this was not put to challenge melody at the time of selection, prior to selection.
Third, as performed. Who is aggrieved by an order dated 8/7/2020 passed by the Director of Medical Education, Assam, by which the case of the petition, after consideration, has been rejected. The order reflects that the petitioner did not possess the minimum qualification of having requisite training on medical record officer. Sarah, the Burma Civil Council of the petitioner has, however, submitted that the state reason of rejection is fully unreasonable. It's not fully unreasonable, as the state condition was one which could not have been fulfilled by any of the candidates, and the earlier reason for not offering appointment being projected to be a tie of marks to candidates from the subsequent cannot sustain that notice is returnable by 4 weeks. The B Group is returned
All the
sending on
response.
Health and Family Welfare Department. On behalf
All the response.
that extra copy.
Lordship, during pendency of this petition, may restrain from
Of course, we will not fill up.
not fill up the
That is not necessary. In the quiz pending, won't be going.
To balance the equity and at this stage the Vermont Senator Council for raise for not to fill up the Google Senate Council. However, there is a reflection of the experience.
No,
Yes,
in the
sir.
speaking order, they have
Yes.
submitted that they will
Last
be going
line.
for
That
press
submits
advertisement
that
now.
two
Because we
there is
try
an
to fill up the
observation.
post.
of big press advertisement for the common.
Sure.
There is no immediate move
Yes.
to fill up the state post. Be that as facts and circumstances and by balance the equity it is submitted that no press must be initiated to fill up the post without taking
No, let it be till the next date. Probably, my lord, tomorrow if they want to relax the qualification, it will be otherwise eligible. Till the next date.
That till the returnable date,
But
no press without taking.
publish.
May I please, Your Lordship? Lordship, this case is regarding the promotion matter. What happened, my lord, the petitioner is working as a junior engineer in the Department of Agriculture, Assam, my lord. And my lord, in the year of 2010, my lord, one DP was constituted against him, and the DP was the proposal was issued in the year of 1999, my lord. And accordingly, that was closed in the year of 2010, my lord, by an order by giving a minor punishment to stoppage of fee increment, my lord. That was passed in the year of 2010. Yes. And later on, my lord, what happened, my lord, the department has constituted a DPC to promote some person to the next higher post of the assistant agricultural engineer in the department. And accordingly, my lord, my name was also considered, my lord. And kindly turn to page 23, my lord, Annex 4, where I have in the garrison list, my lord, my place is serial number 5, my lord. But I have not.
You have not been given the promotion.
Yes, yeah.
You think that because of the penalty of the year
Already
2020,
been over, my lord.
now they are reconsidering the state.
No, my lord, my case is not that, my lord. What happened, my lord? The DPC kindly turn to page 25, my lord. That is the thing, my lord.
25.
25, my lord. Serial number 4, my lord. I am reading. This is the important page, my lord. My case is only in this page, my lord. The board was also apprised the following status of the departmental proceeding against the officers taken under the zone of consideration. Serial number 4, my lord. Ranjit Mohanto, that is me, my lord. departmental proceeding dispose with stoppage of fee increment by order dated 1/2/2010. Prosecution sanction accorded by order dated so and so. High Court case WPC number 7097 2013 Sri Ranjit Mohanto versus State of Assam regarding stoppage of fee annual increment. I have filed a case before your lordship and come to the bottom, my lord. Further, the selection board advised the department to keep the decision of the selection board in seal cover till the course of departmental proceeding and till the final outcome of the Honorable High Court in respect of the following officers. My name is in serial number 2, my lord. Sri Ranjit Kumar Mohanto, to be kept under seal cover till the final outcome of the High Court case number so and so, Sri Ranjit Mohanto versus State of Assam regarding the stoppage of fee annual increment. Only because of the pendency of this case, my case, my lord, I have silenced. I have filed the case, my lord. I have silenced the stoppage of my increment, my lord, and therefore, my lord, I have not been promoted. And later on, my lord, according to that recommendation, my lord, 6% has already been promoted, my lord. Kindly turn to next page, page 27, Annex 6. Here, my lord, 3 persons, serial number 456, they were junior to me, my lord. At this stage, my lord, that case has been disposed of, my lord. Lordship will find this annexer 3, lordship.
Where are the actual appointment orders
My
of the person?
my appointment order is not.
No, not your appointment order.
That is
That is
at page 6, my lord. Okay, page 27, annexer 6.
October 2021.
21.
Why are you doing it up to the
So actually, my lord, what happened at that time, my lord, he has not instructed anything, my lord. Later on, he becomes to know about it, my. And now, my lord,
these promotions were made more than a year back, almost 2 years.
now, my lord, as per the recommendation of the DPC, my lord, the case is already been over, my lord. What happened, my lord? Kindly turn to page. Page 21, annex 3, my lord. This case is already been over, my lord. What happened, my lord? This case was conducted by another counsel, senior counsel, my lord. He has taken up the brief from him, my lord. At this, in the meantime, my lord, case was listed before your lordship and accordingly non-appearance, and the case was dismissed for non-prosecution, my lord.
Yes.
There, at this stage, my lord, there is no any case, my lord. Therefore, my lord, I may be promoted now. Since I have been recommended by the DPC in the year of 2021, my lord.
Yes.
Lordship, and Lordship, there is no whisper about the outcome of the criminal case because prosecution sanction was there. Lordship will find in page 25.
Was there a criminal case?
My lord, criminal case is nothing, my lord.
Against at the top part, Lordship.
No, we have seen, but was there a criminal case? You take instruction.
Yes.
My lord, he says.
Mr. Borua, you should come to the court early if you are aggrieved by an order of 2021.
Yes, my lord. Yes, my lord. That is.
Third D. Borua, let it count for petition who is aggrieved by not considered of his case for promotion to the next higher grade of assistant agricultural engineer by whereas person junior to have been given the benefit of such. It is the case of the petitioner that there was a department against it in the year 1999 which had calculated in an order of penalty, in an order of imposition of minor penalty. This is a minor penalty. The annual increments in cumulative effect.
Yes.
Rule 7.
Where do you get the expression minor penalty?
According to the order, my lord, as per Rule 7,
Yes, rule 7. Is there a distinction?
Three.
Minor penalty and major penalty?
Yes.
Is there a distinction?
that is nothing, my
Not there.
nothing.
Like bank regulation. 64 Act, 64 rules of putting a penalty of stoppage, 3 annual increments with cumulative effect. So, it is the case of the petitioner that only because of state fact, he has been physically deprived from a due consideration. And this amount of case of causing double jeopardy,
Yes.
as the petitioner has already been penalized by imposition of aforesaid penalty. It is further submitted that the audio retribution WP 7097 of 2013, by which the department, by which the penalty imposed in the DP was the subject matter of challenge, has also been. It is otherwise contested that even pendency of the case cannot be a reason to keep the case of the petition under till count. That the beach of the learned setting on agriculture department, however, that the minutes of meeting makes it clear that there are other considerations also, as it talks about a prosecution sanction of the year 2012, which gives the impression that there is a criminal case pending. But he has also submitted that the order of promotion is dated 29 October 2021, and this petition is filed on 21/8, and there is inaudible without comparison. Reader is that would all. These are the done from agriculture department on the all the that extra copies of the
date may be fixed, my lord. Otherwise, my lord, pendency may not be barred to make any promotion during the pendency. Because since already, my lord, like only because of the
they have made some observation that these are the grounds. Unless we set aside those grounds, exception of the
oblige, lord.
Madam, what is this?
This matter is regarding the termination order, which is challenged by the petitioner
Termination of what?
and issued by the managing director Assam.
Termination of what?
Termination for annexure 7, page number 28, Lordship.
Termination of service, termination of lease, what? Termination of what?
Termination for appointment, Lord.
Of the services.
Yes, Lordship.
You
He was
served in-
working as a field assistant, Lordship.
Field assistant. There was
Yes,
a was there any DP? Was there any disciplinary proceeding? The termination was preceded by any inquiry.
Inquiry, Lordship.
There was an inquiry.
Inquiry report is not done. But Lordship, in this connection, similar matters is also pending, Lordship. So
No,
kindly.
it's okay. That is not sufficient. We are expecting from me? What are your grounds? What are the facts?
Facts is that the termination regarding Lordship, actually the question has been arised regarding the legality of her appointment, Lordship.
Yes.
Mm.
You were given a show cause notice.
Yes, Lordship.
Thereafter, you have been terminated. How were you
Show notice
appointed?
is replied, Lordship.
How were you
And-
appointed? How were you appointed? How did you enter into the service?
Appointed, actually, kindly say, Lordship, appointed by the respondent number 4, and
Page-
page number 17, Lordship.
17.
17.
Please read.
Is the administrative approval is sanctioned to Assistant Executive Engineer, Barak Valley, Region to annex the following candidates on daily wage basis as field assistant, Barak Valley Region, at the rate of 444 per day, as there is insufficient field official to collect revenue assessment of fish production, survey and protections of an encroachment, etc., with effect from 15/9/2020 until final arrangement is made.
So this is a very temporary kind of appointment. This is not preceded by any second process. You have been given benefit.
But is approved by the honorable chairman FTC also, annexure 2 and 8, page number 18, Lordship.
Okay, Mr. Sir.
Notice. Other case.
Madam, you are Chakraborty.
Yes, Lordship.
As Chakraborty.
Yes, Chakraborty.
Maybe
Third MS as Chakraborty.
Yes.
check for it.
For petitioner
Yes, sir.
who is aggrieved by an order dated. Where is the order?
Order is
Order dated 37/2022, by which
37, yes.
the services of the petitioner as field assistant
Field assistant.
have been terminated.
Yes, sir.
Submitted that similar issues are pending for including in W 5875. That notice is returnable by 4 weeks. Three terms standing on fisheries department.
Corporation.
Then fisheries
I for 1.3.
CS other state accept notice of they have responsible 1, 2, 3, and 1, 2, and 3. Whereas PP Sharma standing on they have accept notice on behalf of responsible 1, 4, 5, and 4, 5, and
Yes, sir.
3, 4.
Yes. 3, 4, and 5. Yes, sir.
3, you are 3.
Yes.
Oh, there are 2 trees. 4, 5.
Yes,
Four,
sir.
five.
1, 2, 3. Numbering is wrong, Lord.
Numbering
Yes, take, Madam, take this. That extra copy. Of the
Lord,
please.
Lord, may I pray, Lord, in
But at least along with WP 5875. Yes, sir.
Lord, in this early government, Lord, AG is appearing on behalf of.
Doesn't matter. Do not reflect it. Substitute the-
Lord,
They will come.
comply.
Where provides that a diploma holder in engineering, an electricity rules can be posted as a post of an inspector. Then in 2006, my lord, it was abolished. 2006 says that it should be degree holder, but there is a proviso. But on an application of mine for promotion, I am holding in charge of senior inspector. My substantive post is senior grade inspector, but I am holding in charge inspector post.
What is your substantive post?
Senior grade inspector.
Your senior grade inspector.
I want a promotion to senior inspector.
You are a senior grade inspector.
Senior grade inspector. I want a promotion to senior inspector.
Next post is
Senior inspector. I am holding from 2014, my lord, 21, I am holding the post of in charge senior inspector.
Holding that post Working as in-service.
in charge. Now, my lord, I am going to retire on 31st.
Since when?
21.
2021.
I am going to
Do you
retire.
have the eligibility criteria?
My lord, as now their opinion is at page 35. They say that 2006 rule says your lordship may turn to page 34, last paragraph. Page 34, last paragraph.
Yes.
Ajit Kumar Gogoi is a different person, my lord.
Yes.
Now, my lord, at the present rule that was holding in 2006, it says that there is no post for diploma holder, it should be degree in 2006. But now they have given an opinion, the judicial department, he may be considered for promotion to the post of senior electrical inspector if otherwise satisfy the requirement of experience in terms of rule 12(3)(b) of the Assam Inspector of Electric Technical Service Rule 21.
Where are you serving right now?
My lord, I am serving as senior inspector.
Where?
My lord, my post is in at present in Guwahati, my lord. I am working in Guwahati.
No, where?
My lord, that is
Which office?
office is head office Guwahati, my lord.
Bijuli Bhavan. Bijuli Bhavan.
Bijuli.
Yes.
Lordship, I opened the instruction, Lord. That file.
31st August is I am retiring. my lord.
As per the direction of this honorable court, Lord.
Where were we waiting for the last?
My lord, because last order that I approved this court, it was, my lord, they have passed this order on
Kindly see the
This
page
was of
28.
October 2022.
22, my lord, but because
Kindly
last
see the
time
Lord,
there was an order.
paragraph 28 of your desk, that order, Lordship. Page 28, Lordship. The honorable court not properly directed to respondent on one to issue the promotion to respondent to the petitioner, Lordship. Not properly directed to respondent on
Page
one
28.
to appoint to petitioner.
In
Lordship.
doing so, the respondent shall bear in mind petitioner is due to retirement on August 20. He is more than 17 years senior to the respondent. Is also in relaxation of the rules, the petitioner was earlier appointed to function of such and such. Consider a candidate petitioner along with the petitioner.
And this is the speaking order pass.
Speaking order pass.
You are agreed by the speaking order.
My lord, agreed, my lord. If they can,
we will make an observation
my lord,
that if we hold that you are entitled to the promotion,
my lord,
then you have to be given whatever national benefits,
my lord.
and maybe your pension would also be the fitment fee from
My
the
lord.
guiding your
That much will do. That much.
But the PK are toxic. When it comes to petition, the petitioner is a senior grade inspector working under the power department of the government of Assam, and came to holding the charge of the next higher grade of senior electrical inspector since 2021. The petitioner had earlier approached this court by filing WP 4205 of 2022, which was disposed of by an order to consider the case of the Right now the count by drawing drawing here to the impute communication dated 21 can has submitted that in view of the long experience petitioner having as in charge senior elected inspector among a substantive promotion should have been granted he further sub that the time is very crucial as the petitioner is going to attain the age of subordination when
31st start.
by the end of the month. Let no returnable on returnable by 4 weeks. We each of us relative of the all the respondents. That is stock of written upon him within 3 days. We try to the praise for commission for some interim observation. It is needless to say that even this court asked if this court considers it is to say that it even is repeated allowed the petitioner would be entitled notional benefit even including the proper treatment of his pension.
All right.
Give extra copies.
Malata.
May I please, Lord? Lord, the petitioner, my lord, he was a constable, my lord, in the Assam Police, my lord. And he was appointed in 2008, my lord. 15 years he has been served in the department. Due to some, my lord, matrimonial dispute, my lord, cases were filed by the wife, and NBW was issued, he remained absent. And due to his unauthorized absence, my lord, he has been dismissed from service, my lord.
BP was held or not?
My lord, ex parte, my lord, he did not receive any, my lord, to cost, my lord. It was served in the home address. I file appeal, my lord, appeal is pending.
Where is the appeal?
Appeal, my lord, page 22, my lord.
Our article when it comes for the petitioner who is aggrieved
Page 21 order, my lord.
by an order dated 12/1/2023 by which the petitioner who was serving as a constable at the 4th APTF battalion house has been dismissed from service for unauthorized delay. That there was no adherence to the due process of law, and his departmental has also not been considered. That notice issued returnable by 6 weeks. What is your age? Your age?
Yes, my lord. 41 years.
By 6 weeks. That is stock of reserved. No. Create of state council.
CS Hazarika.
Oh, sorry. CS Hazarika, state council accept notes on behalf of all the respondents. That is stock of within 3 days.
During pendency, my lord, my appeal may.
Pendency of this process cannot be a bar for consideration of the appeal. Consideration of the department.
Wait, Lordship. This case, the petitioner appeared in the election process for constable and DD, but they were not selected. But other persons who were unreserved candidates, this petitioner scored more marks than the unreserved candidates, and they did not avail any election. He pays 30. That is the age criteria.
How to answer when it comes for the petitioner who is aggrieved by their non-selection in a recruitment process for the post of constable within package GD in various forces put up. The principal grievance is that though the petitioner had put more marks in the selection, persons who had secured test marks have been given the benefit of appointment.
General category unreserved candidate who scored lesser marks were got service, and these persons who did not avail any relaxation, they should be treated as an unreserved candidate, but the authority did not treat them as unreserved candidate, and they were rejected.
You belong to which category?
I belong to ST category, but I did not avail any relaxation. Therefore, I may be treated as an unreserved candidate. If I am treated as an unreserved candidate, then I may be selected in that case. I would have been
You did not say you are an ST.
I applied in as a ST.
Then?
But Lordship, in the advertisement, Lordship may kindly see page 47.
You do not avail the relaxation, then how do you fit it?
I scored more marks than the unreserved candidate, and I did not take any relaxation. Therefore, I may be treated as unreserved candidate. That is my case. There is page 71. It is a covered judgment also. I have an
No. Principal is that though the petitioners belong to the ST community, they did not avail
Yes.
the relaxation, and therefore they should be treated as unreserved candidates.
Yes.
And since the marks secured by them is more than the marks secured by the last of the unreserved category, the petitioner should have been given the appointment. Para issue notice returnable by 4 weeks. MS Borua, as Borua. And it says to accept notice on behalf of all the respondents.
Yes, sir.
All the that extra copy of the we fix the date of the selection and based on 15th of September on 5. Next.
May I please, Your Lord?
Yes.
My Lord, the petitioner responding to, my Lord, the separate advertisement, my Lord, appeared in, my Lord, one advertisement, my Lord, he appeared for the post of, my Lord, armed branch constable, my Lord. That advertisement, my Lord, may be pleased to find at page 31. Lord, and in this advertisement, my Lord, I became qualified. But what has happened, my Lord, an allegation had been leveled that, my Lord, while I, my Lord, submitted the particulars, I submitted a, my Lord, forced computer pass certificate, my Lord. That's why, my Lord, those selected, but, my Lord, my appointment was kept on hold. Now, my Lord, responding to the stage, my Lord, discrepancies, as CID case had also been registered.
My Lord, when it comes for the petition, who is aggrieved by the action of the respondent in not allowing him to join in a post which he claims duly appointed.
Appointment letter has been issued.
Yes.
Mal.
It is the case of the petitioner that pursuant to an advertisement dated 18/12/2021, the petitioner was duly selected as sub-inspector within bracket AB in the Assam Police Commando Battalion and was accordingly given the appointment letter. However, on the allegation of his involvement
in a criminal case,
in a criminal case pertaining to another recruitment process where he was arrested, the impugned action has arisen. Issue notice returnable by 4 weeks. We talk about that therefore all the respondents. That extra copy of the served on.
My lord, may I pray, my lord, that the post, my lord, in which I was selected, my lord, that may not be, my lord, filled up. Some protection, my lord, if in future.
Your appointment has not been cancelled.
No, no, my lord,
So
not
there is
yet.
no question of filling up the.
My lord.
If it's cancelled, you have another call. That protection will be.
My lord. Obliged.
Meet with your lordship. Lordship, that before this repetition against the order of the 16 November 2021, it is reflected page 152 of my repetition. This punishment was imposed pursuant to the common disciplinary proceeding, and the punishment is reflected page 162, paragraph 17, serial number 2, lordship.
You have not preferred departmental appeal.
Lordship, that this order has been issued by the Director General. So provisions of departmental appeal provision is not here, lordship.
Why?
Lordship, DG is the head of the department, lordship. In the armed forces.
The ministry will not lie.
Yes, and this order has been issued.
The appeal would lie.
Lordship,
The CRPF rules. There is a provision for appeal.
Lordship, this order has been issued in terms of the direction of the president, lordship. So order has, there is no provision of enforcement.
Which rule?
Rule, lordship, that he is a head of the department.
Which rule?
Rule, CRPF rules, lordship. Rule 28. Rule 28, lordship. Offense CRPF rule. And the punishment has
By the DG.
DG, lordship, and
Let
the
us see page 152.
page 152, lordship, and the page 161, paragraph 16, it is reflected that disciplinary authority, that is the Honorable Home Minister, lordship. Page 161, paragraph 16.
This is issued by whom?
This is issued by the DG, lordship, Director General, on the approval of the Home Minister. Paragraph 16, page 160.
Not by the DG.
Lordship, that it is a Director General, CRPF, lordship, page 150, it is reflected in the impugn order.
DG or DI?
Lordship, order was,
How do you write it?
lordship, that order was issued by the DG and the DIG had signed it.
Where do you get it?
Lordship, that page 152,
Yes.
Annexure 7, Director General, CRPF, Ministry of Home Affairs.
162 days.
Yes, why? And the 161, page number 16, paragraph 16. 161 of my page number 161, paragraph
Yes.
16. And where is the disciplinary authority? The Honorable the Home Minister.
So his approval has been sought. He is not the disciplinary authority.
Yes, Lordship, it is recorded in the disciplinary authority in the order itself.
He is not disciplinary authority. His approval has been sought.
Yes, Lordship.
Mr. Gupta, what
My
you
lord,
say?
UPSC is also need to be made a party because
No, as part of that. On this issue, what Mr. Vesboro is trying to show at page 162, 161, paragraph 15. Or Home Minister has been termed to be the disciplinary authority.
Lordship.
Yes, for a second, Commandant, you are a deputy commandant.
I am the deputy commander.
The Home Minister becomes the deputy authority.
my lord.
Mr. Gupta,
But I have to take
you
one.
come to the rule.
My lord.
May take it that then take it at 2, Lordship. Then I will check it, Lordship. But
Please check.
yes.
This against whom? Item number 1 to 11, column 2, the table.
And the memorandum has been issued by the President, Lordship. That is reflected paragraph 2, page 152. Paragraph 2, Lordship.
So we'll have it at 2. Just have a
No,
look.
I'll
at it here. Regarding the highlight.
my lord.
May please your lord. My lord, before I take your worship to the orders consumed, may I give a brief my lord, background of the case. The petitioner is presently Assistant Registrar of Cooperative Societies.
Is it?
Assistant Registrar of Cooperative Societies. She got married at a very young age, and although she by birth she was not from the scheduled caste community, but she was born and brought up in an environment of the my lord with all the difficulties that the my lord backward communities face, and eventually my lord got married. Then my lord she appeared in the STS examination in 2006, 2002. My lord, she was appointed. Appointment was in 2002. Then what happened, my lord? In 2007, after 5 years of her appointment, a complaint was made by my lord, the secretary of the Coordination Committee of Scheduled Caste and Scheduled Tribe organization that petitioner doesn't belong to SC. She declared herself to be SC in the application form. Therefore, then action should be taken. On that basis, my lord, the deputy commissioner cancelled the scheduled caste certificate. Then, my lord, a DP was drawn against her. And the DP, my lord, after the, my lord, inquiry, my lord, that DP was dropped. That your order, your lordship will find at page 79, page 124, my lord. Then, my lord, that was in 2015. Then in 2016, my lord, one MLA, my lord, raised this question in the assembly. And pursuant to that, the Committee on Welfare of Scheduled Caste and Scheduled Tribe, Assam Assembly ordered an inquiry by retired IAS officer. Then, my lord, on the report, on the basis of the report, the committee recommended.
What's your grievance?
Grievance now is that, my lord.
Your the earlier proceeding has been satisfied by the
yes,
and affirmed by the Division Bench.
Yes.
Now, what's your apprehension?
My, if your lordship kindly comes to the, my lord, the two orders I'd like to, my lord, point out. So far as the division bench order is concerned, my lord, if your lordship comes at, my lord, page 172, it starts.
Now, at this stage, what are you expecting some interim order?
Yes, my lord.
How what?
I'm just, my lord, trying to. My lord.
No, we have to know something about your fact.
My lord. Now, direction that has been passed by the division, honorable division bench, your lordship will find that, my lord, at page 179. That is the direction.
Yes.
Direction is, my lord, in fact, your lordship may kindly read
We
from
have seen that.
paragraph 12.
We've seen that.
Now, my
we
lord,
given opportunity of hearing, follow
Yes.
the rule.
Yes.
Now,
Follow the rule, my lord. Yes,
let us see 10, 8, 20.
I'm on that, my lord. They follow the rule.
10, 8, 23, let us see 10, 8, 23.
10 at 23.
192.
Yes, my lord. 192, your lordship will find that after the, my lord, inquiry, 192, it is said, my lord, finally, at page 194, accordingly, it is hereby decided that Srimati Bornali Tamuli may not be allowed to continue as a general category candidate in service. So, my lord, what it contemplates now is that there has to be some further order. Because she is continuing, my lord, this only says that she will not be continuing as a general category candidate. And next sentence, your lordship will kindly see, my lord. The appointing authority may consider to issue necessary orders as per decision above in terms of the Honorable Guwahati High Court order dated 27.
Let us just have a look at the operative push which you are trying to.
Yes, my lord.
So at 27/1/2020.
I'd like to read, my lord, if your lordship kindly bears with me, paragraph 12, my lord, at 178.
One 78.
178. Paragraph 12. May I read it, my lord?
Yes.
Considering the matter in its entirety, we direct this Chief Secretary to the Government of Assam to examine the aspect, peruse all the relevant materials on record on the aforesaid question, and also take note of the prevailing legal principle as to whether a person having been appointed as a reserved category candidate upon it being later on found that such person is not entitled to continue as such, whether without any further deliberation, the person concerned can be allowed to remain in service as a general category candidate, meaning thereby the Chief Secretary would also be required to examine the aspect as to whether the respondent number 1 on merit otherwise would have been entitled to continue as a general category candidate. This is important, my lord. And whether in the circumstances where she had entered the service on the basis of an incorrect certificate can be further allowed to continue in service as a general category candidate. The Chief Secretary to also consult the APSC and obtain their view whether the respondent number 1 can be allowed to remain in service as a general category candidate. In doing so, the Chief Secretary to also issue notice to the respondent number 1, Srimati Bornali Tamuli, and give all required opportunity to the person to present her case and also allow her to produce any relevant materials or law as she may desire, and the Chief Secretary thereupon to take a reasonable decision as to whether the respondent number one, Srimati Purnani Tamuli, is required to be allowed to now continue as a general category candidate. Depending on the recent order that may be passed, the further continuance of the respondent number one, Srimati so in service shall be governed by. The recent order be passed within a period of certain. Now, my lord, in this operative portion, your lordship will find, my lord, the chief secretary has been given the, my lord, the responsibility to continue and also to consult the APSC. Now, my first submission is that, my lord, this entire exercise, my lord, is there is a, my lord, very serious civil consequences, and therefore the Assam services.
APSC consultation has been done on.
It has been done, my lord. That is also not. If your lordship kindly comes to the report of the inquiry committee, APSC's consultation is, my lord, half-hearted. If that your lordship will find at page 190. Therefore, two questions, my lord: whether this has been done correctly, and secondly, my lord, whether disciplinary appeals rules ought to have been followed. Now, if your lordship kindly comes to page 190, last paragraph, has your lordship got it, my lord? The commission examined the matter, and after due verification of relevant documents, found that Srimati Tamuli obtained the marks less than the cutoff marks meant for general category for the post of ARCS in CEE 1998. And the commission as such is not in a position to recommend her against the aforesaid post as a general category.
Where is the consultation with the APSC?
The other document I do not have.
No, in the impugned order. Where is the reflection?
193, my lord. Paragraph 3 at page 193. The commission examined the matter, and after now, my lord, on this, my lord, verification by APSC, I have got a submission to make. Firstly, my lord, when an applicant, my lord, applies for the SCS post, he or she applies for the SCS post. He doesn't apply for ARCS or DTO or ACS class 1. She was selected in class 2. In class 2, not only ARCS is there, other posts are there. Here, the, my lord, APSC has only considered whether in the ARCS, those persons who have been appointed at ARCS, the lowest one, what is the cutoff mark of the lowest one compared to the, my lord, petition. That, my lord, exercise ought to have been made in respect of, my lord, other class 2 categories also, because it was not by her choice that she has become an ARC. So that exercise is, my lord, not complete. That is one of my submission. And second submission is that, my lord, the direction of the division bench is to cause an inquiry, and, my lord, for that the rules are there, my lord. Disciplinary appeal rules have to be followed, my lord. That has not been followed.
After the division bench observation, you have not agreed by the division bench order.
My lord, it came from your
they have done what the division bench has directed. We don't find that there is any deviation from any of the.
My lord, the question
the earlier submission is that may be a relevant submission. That if you treat me as a general candidate with the marks which I obtained, I may still be entitled to be in the service. May not be as a ARCS, but in some other categories which may be below. That may be a relevant submission. But prima facie, we are not finding any deviation from the rule. Because
rule,
they have done.
By rule, your lordship has it has fallen from your lordship about the rule. My lord, rule is Assam service.
No, rules would come into effect. Would keep but now here is the division bench order which has laid down certain guidelines that do this, do this, do this. Everything appears to have been done, and you are not aggrieved by the division bench order.
No, my lord. So far as division bench is the judgment is concerned, depending on the upon, my lord, what your lordship may ultimately say, they are preparing to go for the matter.
That is a different thing. And this order appears to have been passed expert.
Yes.
I don't think you were there.
In this,
DB. No, it's the DB.
DB is
you were heard.
But then, my lord, if your lordship is the final impugned order, they are.
Yes, who is appearing? Madam Mayor, for whom? Who's 1 and 2?
Personnel department.
You're for the government.
Yes, Lord.
And yes,
correspondence and
cooperation. Don't have much The 1 and 2 are the main responsibilities.
My lord.
5. Yes. What are you contemplating, madam?
Lordship, after the division bench order, Lordship, if your Lordship may kindly peruse page 192, Lordship.
No, madam, if you have heard us properly,
Yes, Lordship.
we are not finding too much fault with the order.
Yes,
But
Lord.
there is one submission made. That the appointment was made long time back,
Lordship.
and it is not a case of suppression or something. It's a case of interpretation. Okay, and as per law, she may not get the benefit of that, and she be treated as a general category.
Lordship.
But he was appointed as ST. Now, after so many years, you have come to a decision. No, he should be treated as a general category.
Lordship.
That may be a correct decision. But after so many years, if you are finding some fault with her category, which he was inducted to serve, then there are other services that even if she is treated to be a general category candidate with those marks, she may fit in some other post in which a general category candidate was appointed at that point. So after so many years,
Lordship, even
moving
after
from ARCS without even exploring that option, that whether other posts could be there where she could be accommodated with those marks in that case.
Lordship. But on the basis of the order of the division bench, Lordship, the committee has been constituted, Lordship, and where the opinion from the APSC was also sought, Lordship. So everything has been done following the order passed by this honorable court, Lordship. And the person concerned, the petitioner, he himself, herself was also present, and she presented her case also.
No, we have understood.
Yes, Lord.
With this mark, if she is treated as a general category,
Lordship.
she will not get the job of ARCS.
Lordship.
That much is clear. But with these marks, did you undertake any exercise that
Lordship.
post which were filled up by general category candidates
Lordship.
could have been given to her with these marks? Yes. That is the question.
But after this Lordship examined the matter and the commission examined the matter, and after due verification of relevant documents found that Srimati Tamuli obtained marks less than the cutoff marks meant for general category.
In which post?
In the post of ARCS
That
in
is
CC
it. We are trying
1998.
to put it to you.
Lordship.
ARCS is okay.
Lordship.
But in civil services, there are various posts.
Lordship.
It depends on what options one gives. Maybe the ACS gets the highest mark, and maybe APS, and there are hierarchies.
But this is Lordship.
That's why
SC, because at that time the certificate that she was holding, Lordship, which has been cancelled subsequently, Lordship. So there was no option because she should have been treated in the general category, because the certificate that she was relying on subsequently been cancelled. So the reservation what she obtained was actually should not have been, because it was should have been availed by some other.
Madam, it appears that you have not understood or you have not listened to the court at all. You concentrate here the question, madam. Look here.
Lordship.
We are asking a question. You are not even understanding or not even attempting to understand.
Lordship, I understood.
Have we said that we are tampering with we are interfering with the caste category? We are not. You treat her as general. But as a general, was she entitled to any post with those marks? That exercise have you done or not? That is the question.
Lordship.
Are we saying that no, you treat her as ST or ST? That is the finding of fact. We are not interested.
Lordship.
General category has got more marks than her. That is okay. The ARCS is gone.
Yes, Lordship.
But there are other posts.
Lordship, on that particular count, Lordship, I shall appraise if Lordship may kindly allow me a short time.
Sri
Lordship.
M.K. Chaudhary, London account for the petitioner, assisted by C. Bharadwaj. This matter has a checkered history. The petitioner was born as a general caste, who was born as a general caste, but was unserved by her marriage.
No, even upbringing, my
Hmm?
even upbringing.
Even Abigail was brought up
In a
by
community.
by one Sri Durgeshwar Bora, who belonged to the ST community. The marriage of the petitioner was also which a person belonging to the ST community, and according for all purposes, the petitioner being treated as an ST community and obtained a certificate of as a candidate belonging to such community. The petitioner had participated in a recruitment process in the year 1998-1999 conducted by the APS as an ST candidate and was ultimately selected and appointed as ARTS. Long after her appointment, there was some allegation regarding her caste certificate, which had also supplied, which was also later on withdrawn. However, subsequently, the same issue again cropped up, and a disciplinary proceeding was initiated in which it was held.
Exonerated.
No, the later one. In which the petitioner was found guilty. The petitioner had thereafter filed a writ petition WP 2864 of 2018, which was allowed by this court by interpreting with the so-called the state order of the Learned Single Judge was the subject matter of WA 8 of 2022, preferred by the state respondent. The Honorable Division Bench, while upholding the order of the Learned Single Judge, had, however, given liberty to the respondent authority, to the state respondent, to issue notice to the petitioner, afford a hearing, and pass necessary orders by consulting the APS. Pursuant to the state liberty, the state respondent have asked the impugned order dated 10/8/2020 through the Chief Secretary of Para. Not Para. The finding of the state order is not to allow this petition to continue as a general category candidate in service, and the appointing authority was accordingly directed to consider necessary orders. The senior counsel for the petition has submitted that the direction of the Honorable Division Bench has to be complied by, has to be construed by reading into the observation of the procedure laid down the Assam Discipline and Appeal Rule 1954 and the proceeding which appears from the order dated 10/8/2020 appears to be a summary proceeding in which there has been violation of principles of natural justice. Alternative, the senior counsel sub that even if the order is sustainable on merit, the consultation with the APS as directed by the Honorable Division Bench does not appear to be a proper consultation, as there was no discussion made on the aspect as to whether, even if the petitioner is held to be a general category candidate, he would have been entitled to get any other appointment in the various posts which was a part of recruitment process conducted by the APS in that year. Also heard I also heard the state council appearing for the number 1 and whereas also heard you are a sitting council of the corporation department for the corporation department and your name AD on behalf of B. Sharma for the APS. We issue notice or we allow you to have a structure.
Yes, Lordship, because the appointment, they are yet to issue necessary order, Lordship, on that particular point I'm just.
MS Bhattacharya submit that before issuing formal notice, to be allowed to have a structure as final orders are yet to be passed. That the aforesaid pair appears reasonable. According that matter will be listed after a week on Friday night.
Lordship, yeah.
On
First.
On first September.
Lordship.
1st September. The learned state council to operate the structure. Is however to balance the equity and serve the interest of the is directed that no final orders be passed till the next, that is next first. The respondents may also explore the option of having the services of the petitioner in any other post which he would have been otherwise entitled if to as a general.
Highly obliged.
Lordship, I may be allowed to get a copy of the order.
You are always allowed. That an extra copy of the list upon MS Bhattacharya to enable her to do that. On the proposal.
The CRPF rules, rule 110.
Yes.
Yes, that says that all the superior officers for discipline and appeal purposes will be governed by the CCS rules.
My lordship has the CCA rule. Rule 22, he suggests orders against which no appeal lies. Notwithstanding anything contained in this part, no appeal shall lie against any order made by the president. Lordship has the rule, rule 23. Rule 23 of the CCA rule. 23. Notwithstanding anything contained in this part, no appeal shall lie against any order made by the president. Thereafter, Lordship may like to have Rule 29A.
Yes.
Rule 29A is to the effect the president may at any time, either on his own motion or otherwise, revise any order passed under these rules when any new material or evidence which could not be produced. Now, this is not the case here, my lord. So now, if Lordship would kindly have a judgment I had just placed before Lordship. There, if Lordship has a para 9. So, para 9, my lord. The last 3 lines of page 5.
What has been told?
Hello?
What has been told?
My lord, it says, look at the fact situation of the case. Power has been exercised formally by an authority set up under the rules to do so, but effectively and for all practical purposes by the Chief Minister of the state. To whom do you appeal in a state administration against the decision of the Chief Minister? The cliche of appeal from Caesar to Caesar's wife can only be bettered by appeal from one's own order to oneself. Therefore, this is a case in which the High Court was not justified in throwing out the repetition on an untenable ground that the appellant had an effective alternative remedy. High Court did not pose itself the question as to formula. So the Article 226, it would be applicable, is what has come here. Now, if Lordship has the repetition for a moment, the final orders which are passed, not only in the name of the President, but Lordship will find it says, whereas the disciplinary authority, that is the Honorable Home Minister.
And that is the, what is the criteria looking for? Is the Home Minister the disciplinary authority?
It was not. That is one of the grounds. But that
My
this,
lord,
this may be one of the grounds in the repetition, but Lordship will kindly have.
The disciplinary authority, who is the, you are a deputy commander.
My lord, yes. I am appointed by the President. My appointing authority is
understood. But who was the disciplinary authority?
He was not the disciplinary authority that they will come up saying that it's a misnomer, because at the end of the day, Lordship will find at page 162. Therefore,
No,
in the
we have-
light of the above,
We have seen the use of expression.
my lord,
The Home Minister is the disciplinary authority.
Yes.
Is that done intentionally, or is it a misnomer, or is it by
The power
error?
can be delegated, my lord.
It is not.
President of India can delegate. the
it is
power.
not, because it is not a question of delegation, because at para 17 they say the President considers that the end of justice should be made if the penalty of so and so is imposed. Disciplinary authority, that is one of the grounds that disciplinary authority, if they take it to be the Secretary, the President being the appellate authority had no business to impose the order. And if it is the President who had to exercise the jurisdiction, then the Secretary should not have interfered by putting in his own expressions in the entire matter. It should have been left to the total discretion of the.
But it is conveyed by the DI.
It is conveyed by the DI under orders of the President.
This is notice may go, but I will take.
That is to be a part of deliberation.
Lord, one more thing, my respondent.
Other cases of commandant involved with commandant, no appeal lies, or rather the statute does not prescribe for an appeal. So there are many other posts above the post of command.
DIG, IG. The DIG would be there, DIG, IG, and the DG. For all of them, it is the President who's the
Group A officer.
Third, three, R. Mazumdar, Senate Council, or petition, who is aggrieved by an order dated 16/11/2021, by which a penalty of reduction to a lower stage in the time scale of pay by 2 stages for a period of 2 years with further direction that he will earn increment of pay during the period of such reduction, and on expiry of such period, the reduction will not have the effect of postponing future increments of pay has been imposed. The petitioner was serving as the deputy commandant in the Central Reserve Police. What are your grounds of challenge?
Well, that evidence, proper evidence has not been appreciated, evidence has been left out.
What is the
Irrelevant, my lord. That me and the commandant the in-charge commandant at that point of time, we had a scuffle on the field in front of everybody.
The charges against the petitioner was of act of remiss in discharge of duty. The Mazumdar, the Senate Council has submitted that the rules governing the sweep do not prescribe for an appeal. That notice should returnable by 3 each of the learned accepts notice on behalf of responsible.
1, 2, 3, and 5, my lord. The 4, my lord, inquiry officer is made a party, my lord. My lord, because the very
Not by
not required.
Not
By name,
It's not by
otherwise.
name.
1 to 5. All the rest. That extra copies of petition is served upon him by within 3 days.
Obligement.
Well, the matter relates to sexual harassment to women at her workplace. Petitioner was contractually employed at in the premises of Assam Textbook Production and Publication Corporation Limited in contractual basis. She has been sexually harassed by one of her colleague. And she initially there was no internal complaint committee.
Now, what is your demand?
Grievance, my lord. Now, my lord, earlier I have approached this honorable court, my lord. During earlier litigation, my lord, they have constituted the internal complaint committee and they have said that they have already, my lord, initiated the process. But, my lord, after that order, my lord, they have issued a letter to me to file the written statement. Accordingly, I have submitted the written statement on 11th of June, my lord. And thereafter, they are doing nothing. Whereas there is a statutory period of 90 days from the date of submission of the complaint. They have complaint committee has to submit the report. And one of the grievance, lordship will find page 38, annexus 6. They have constituted the complaint committee. A complaint committee, as per rule, section 4, of the sexual harassment of women, that provides, chairman has to be, woman in any case. But here, the chairman is a male person. So this complaint committee is also illegal.
Textbook production has got a
actually notice. Yes, notice was addressed to them. Notice was received by the elementary education. That is why perhaps they have not received the notice.
Which notice?
I have. While filing the repetition, notice was addressed. Lordship will find the third file. It was addressed to the text.
Name shown or not? Is there any standing counsel?
My lord, PN
Let his name be shown. We'll have it on possible Tuesday or Wednesday. Third free entry for the learned counsel for the petitioner, who is aggrieved by the lack of proper action as per the sexual harassment of women at workplace, prevention, prohibition, and redressal, bracket to the Act of 2013. Apart from inordinate delay in dealing with the matter, given the constitution of the complaint committee is not in accordance with law. Sir, at this stage, however, Sri P.K. Bora, Learned Standing Council, Learned State Council,
Standing on.
Standing Council, Elementary Education,
My lord, for respondent number 1, my.
Elementary Education has submitted that the Assam Textbook Production and Public Corporation Limited has a standing council. Sarah, is this case for motion on
Tuesday, that my.
Tuesday on the by Secretary here to standing council.
But if copy not, sir, I will give a copy to him.
Monday you can keep that.
Monday, then, my.
You the copy of this order, get it the next step.
My lord.
If the case of the petitioner is that petitioner was deployed on duty at 400 kV news store. During night checking, Lordship, at 3:10 hours on 24/8/22, SI Pinto along with one Constable GD, HB Chetri came for surprise visit, surprise checking, Lordship. And while
We are the Senate counsel for the petitioner who is aggrieved by imposition for penalty of censure, which on appeal was enhanced to 5 days pay, to a fine of 5 days pay. Full stop. Issue, the petitioner was, what was your posting?
Posting at Salakati, Lord.
What as what? Your posting as what?
Constable GD.
The petitioner was posted as Constable GD
in CISF
at the 400 kV news store. Where? At Salakati.
At Salakati.
What did you do? You said namaskar.
Yes, Lordship, that is my fault, Lordship. I saluted him and regarded him as namaskar, Lordship, that he told that it is not permissible in CIS.
Is it the true word? Or with namaskar you said something else?
No. Only namaskar. But in the article of charge, they have still.
What was the time?
Time was 3:10 hours, Lordship.
In the afternoon?
No. AM, Lordship. 3:10 AM.
AM.
On 24/8.
We are doubting whether it said namaskar or something.
Yes, Lordship, namaskar. Because there is a.
You said namaskar standing or sitting or by lying down?
No, by standing.
You could say that 3 o'clock.
Yes, Lordship. Because my duty is the night duty. And one Constable GD, Shimon Kumar Shahu also corroborated that. Number I.
It should admit. As Vishwakarma.
K. Vishwakarma. On behalf of Mr. S.P. Chaudhary.
Learned counsel appearing on instruction of S.P. Chaudhary. Learned accept notice on behalf of all the respondents. That extra copies of the writ is served upon him within 3 days. Full stop. The Vishwakarma is also directed to seek the records of.
Published.
List of the 4 weeks. A list of the 4 weeks.
Published.
make to the lordship. My lord, in this case, I have a limited prayer lordship. My name was recommended by the SLC lordship, page 66. Lordship, there is an observation that vacancies are, as and when vacancy lordship, they will consider lordship. But lordship, I pray lordship, since in the agriculture department, some vacancies I have referred, annex the same also. They may consider even in driver post
My
also.
submission is lordship. Kindly, lordship, applicant, petitioner has to, water resource department as a make a party lordship.
No.
There, so in the recommendation letter, lordship, kindly see the recommendation letter, lordship. On page 65, lordship.
I'm not on 65.
65, SLC.
My name is 6.
On this part.
Petitioner did not have the qualification for the post.
Therefore, the water resource department will issue,
No,
take
no,
up
no.
the matter, accommodation for the,
No.
for consultation of the department, lordship.
Lordship,
That's why, lordship.
Page
Agriculture
60
department has no sufficient post, lordship.
lordship,
Grade 4 post.
I pray lordship. May I read lordship? Perhaps wrong page.
What is your name, Mr. Malhotra?
Uttam Kumar
Kumar
Das,
Das.
lordship. My serial number 6, lordship. The DSC congratulated so and so recommended the petitioner's name. In compliance with the SLC recommended C. Uttam Kumar Das for grade 4 post in personal departments, and the department will accommodate him in consultation with the department against available grade 4 vacant post. Since agriculture department does not have 5% cadre so and so in consultation with other department against the available vacancy.
Sorry, lordship, sorry.
Then lordship, page, lordship.
You now say that there are posts vacant.
Lordship,
Yes,
page
Mr.
6,
Chaudhary,
page 68, lordship, I have shown the vacancy.
issue a short notice.
Lordship, he may give us a complete minute of the SLC because it
So
doesn't
you issue
tell.
a short
It doesn't tally, lordship.
Third
with each of
thing,
the
Malhotra, and a conflict for the petitioner who has filed this petition with regard to his consideration for appointment on compassionate ground. It is submitted that the SLC had considered the name of the petitioner. It meeting dated 22/2015, and in the remark it has been stated that there are no vacancies in the concerned agriculture department. The Learned Council, however, has submitted that there are vacancies where the petitioner can be accommodated.
Page 68, lordship, and driver posts are.
In this regard, certain documents have also tied up, which are annexed to the should be returnable on which date.
Lordship,
Lordship,
On 18th September. We Chaudhary Lieutenant of the Agriculture Department has notice on behalf of
1 and 3, lordship,
1 and 3,
and 5.
1, 3 and 5. Whereas we talk about state council access notice on behalf of respondents 2
And 4.
2 and 4. That extra copy for
lordship,
the Learned Council for this one. When by Monday,
lordship. I have a small prayer, lordship. One post, grade 4 may be kept vacant, lordship, because so that he can be accommodated, lordship.
so the matter is for the court technical instruction.
Lordship.
Pagination is different, lord. That's why. Pagination is different, lord.
Usually, sometimes any pages, lordship,
Why do you confuse your colleague? He'll also put a wrong number in your page. In your
Lordship.
You also do that.
Sorry, lordship, I.
Or you do one thing, you give him an affidavit in other of some other.
Sorry, lordship.
Made, lordship, new subject, but I am trying to apply your lordship. My lord, petitioner is challenging the order of termination that your lordship will find at page 62. I have been, my lord, because of my lord, this is settled law, your lordship. When criminal and departmental proceeding can go simultaneously if it is based on same facts and evidences are not same, your lordship. If it is not based on. In the present matter, your lordship, the evidences, witnesses, allegations, all are similar. In fact, matter is covered by division bench decision of this honorable court. And your lordship is the author of that judgment, your lordship, given in Itanagar bench. May I apprise your lordship? And I will show charge sheet and
What was that case? Santos or something?
my lord. Yes, my lord. Komik Kadu.
No.
Supreme Court case.
Supreme Court, sir.
Paul Anthony.
M. Anthony, Rajkumar Lal.
Not the last case of waiting for one year. Santos. What was
My lord,
Santos?
my lord, the basis
What are
on
the
which
cases-
your lordship
what
has
are the cases referred?
uh,
Santos or something?
Kuseshwar Dubey, M. Paul Anthony, Rajkumar Lal, Komik Kudu, Itanagar bench, Komik Kudu division bench, your lordship. These are
And then last,
Komik Kudu because
there's a matter, Santos or what?
one Rajasthan High Court decision.
No, Supreme Court. It said at best 1 year you can wait
My lord.
till the
But your lordship has
giving
relied,
time space for completion of the
my lord.
disciplinary procedure.
True, your lordship. In fact, against the main accused, my lord, he approached this honorable court, and matter has been placed, my lord.
Now, what are you seeking in here?
My lord, I am because I preferred appeal also.
What is
And-
your prayer now?
Prayer is, my lord, notice and stay of that order, your
Day
lord.
of what?
Stay of termination order
Oh, it's already been terminated.
on removal, your lord.
You have come at your,
My lord, I approached the appellate authority, my lord.
you have come much
But
later.
in the Itanagar, my lord, it was terminated.
Well, it is not a question of continuation of two proceedings simultaneously.
My-
One proceeding has come to an end, it's been culminated with an order of
True, your lord. Same question was there in Itanagar, and your lordship has interfered with the termination order.
on
And
the
that-
first day.
Not first day, my lord. I am saying that it notice may be issued.
Termination cannot be stayed.
My lord, my lord. As your lord, as your lord.
We'll
But
examine
my lord,
We'll
appeal is
definitely-
pending, my lord.
we'll Definitely examine.
My lord, appeal is
And
pending.
we'll say that penalty may not be a bar for consideration of your.
My lord, as per rule 24, my lord, it has to be
Sir,
decided in
we
3
need to
months.
When it comes for petition, who has put to challenge and ordered it is 16/5/2023, whereby the petitioner has been awarded the penalty of removal from service. The petitioner was serving as what?
Constable, your lord.
As a constable
Women constable.
in the constable under the Assam police, and a department proceeding was initiated against him in connection with a criminal case which was registered as Korodum case number 479 of 2020 under section 379 411 of their penal. So, the state proceeding had culminated in the aforesaid order of penalty, and in the case of the petition that a departmental effort, as prescribed by the rule, has also been preferred in the meantime and is pending consideration. So, it is the contention of the petition that the penalty is not sustainable as the charge in the disciplinary proceeding is identical to the charge in the criminal,
And evidences and witnesses are same.
and the evidence in both the cases are admitted. Call for the record. Don't say call for the record. Then see as other done it state council except behalf of
All the
not railway police. Not railway police.
Railway police is also Assam police, your lord. He has been
Not
posted-
here, not here.
Not GRP. GRP means GRP, your lord. So GRP is also Assam police. He is superintendent of railway police. Head of GRP.
GRP is in the sub.
Assam police. Assam police. State police. RPF is railway. He's the disciplinary officer.
For all the rest. That extra copy of written be served upon upon him by witnesses. Where is your penalty order?
Penalty 6-2, your lordship. 6-2. And really, operative part, my lord, 64.
List of the the London State Council is also direct to secure the record of the case. Sarah, penalty shall not be a bar for consideration and disposal of the department. Yes.
Here only the superintendent of police SPE.
My lord, it
not
is
railway.
not railway, my lord. This is my mistake. Railway is also within Assam police, but it is not railway. Only superintendent of police. Railway, I will. Superintendent of police, SB.
Now the whole thing has to be, otherwise.
Only railway part.
You do one thing, whatever said, but you file a IA for correction of fee. Nowadays, because of CIS system, you are not allowed to collect for it.
Absolutely. That will deeply. Okay.
Yes, what is this?
May I please, Lordship? In response, the respondent authorities publish a notice for recruitment of the Constable JD in Central Armed Police Force. Lordship. Accordingly, the petitioner has applied for the post of Constable JD, Lordship, and he has successfully passed the written examination, Lordship. And thereafter, he was called for physical fitness test and physical standard test, Lordship. Both the tests he has qualified, Lordship. After, Lordship, the petitioner was called for detailed medical examination, Lordship. In the detailed medical examination, Lordship, finally comes to page 56, Lordship. Annexus 7, Lordship. He was unqualified due to blood trace, urine blood trace, Lordship, which was examined in the Nayana Hospital, Lordship. Therefore, again, he was referred to the review medical examination. Finally, page come to the next page, Lordship. Next page, Lordship. So, in the review medical examination, Lordship, para 1, 2, 3, Lordship. Report brief, 2, Lordship, brief review medical examination and finding thereof, blood urine in trace, Lordship. Report of Narayana Super Specialty Hospital.
Page.
Next, page 57, Lordship.
57.
57, Lordship.
Yes.
Okay. Para 2, Lordship. Lordship, got it, Lordship? Yes. Brief of review medical examination and finding thereof, Lordship.
You are in page 57.
57, Lordship.
Yes, blood traces in urine.
Blood traces in
That
urine,
was the reason of being unfit.
Unfit, Lordship.
Thereafter,
They also mentioned the report point Narayana Hospital blood test, Lordship. Next page, Lordship, 58, Lordship.
yes, 58.
58, Lordship. Lordship, kindly come to the down, Lordship, to down 2, Lordship, blood urine report, Lordship, not detected, Lordship, in the review medical examination, Lordship. But the respondent authority, Lordship, illegally unfit the petitioner, Lordship.
No, this is your report.
Yes, Lordship.
What is done by the authorities?
Authorities, Lordship.
Where is the endorsement?
This is not my report, Lordship. This is the authorities' report, Lordship. Respondent report, Lordship. They have said here the report of Narayana Hospital is a special hospital, Lordship. It has Lordship. Page 57, Lordship. Unfit report, Lordship. In the detailed medical examination, Lordship, they examined the whole body of the petitioner, Lordship. Lordship, from top to bottom, Lordship. Thereafter, Lordship, they have tested the whole blood test, Lordship. In the blood test, all are correct, Lordship. He is found to fit, Lordship. Only this little bit, Lordship, they are saying that it is unfit, Lordship. It is a minor infection, Lordship, which was not traced, Lordship. Next review medical examination, Lordship. So, humble submission before this, Lordship. There are other judgment, Lordship. Earlier, before this honorable some petitioner came, Lordship. They were also direction this honorable court.
Yes, madam. What is this?
Notice I have to go, Lordship. I have to take instruction.
And already final select list was published on 21/8/2023. Final select list.
Although the final list was published, Lordship, but there is some vacancies there, Lordship. I annexed the list, Lordship, in the Assam portal, Lordship. And the petitioner has got the written a cut-off mark. He has got more marks than cut-off marks. He has secured more marks. Lordship, earlier judgment, Lordship. Yes.
This report is of which date? Page 57.
Page 57. Report is given by the
Which date?
Assam State, Lordship.
Date.
Pardon, Lordship?
Date of the report.
Oh, date of the 26,
26/7.
Lordship. 26. Here, below.
Previous report is on 24/7. Page
Two report is
54.
there. 26, Lordship, left side, Lordship. Page 57, left
No,
side.
no, if you are saying that this report by which you have been held to be unfit
Yes, Lordship.
is based on a report of the Narayana
Hospital.
report specialist.
Yes.
And for this report, you see, this was collected on 26/7/2023 at 3 p.m.
Yes, Lord.
Received at 3:20, and report is on 4:15 p.m.
4:15 p.m. Yes, Lord.
So the report of rejection is after 4:15.
After 15 p.m. Lordship. Thereafter they publish it.
Or is there any other report?
No, Lordship, after this verification, the report, Lordship, they reject it, Lordship. They are going the earlier report, Lordship, also, Lordship. Lordship, finally come to the page.
Earlier report, let us say earlier report.
Earlier 54, Lordship.
54 page.
54 page, Lordship. Annexer 6, Lordship. They have done 2 tests, Lordship. 54. Here, blood urine is traced, Lordship. After this report, Lordship, they have given the for review and examination, Lordship.
That is the issue. This report, which was done on 24/7,
Yes, Lordship.
obviously this was on 26/7, isn't it?
Yes.
So that was the report which was taken into consideration. You are now saying that this is not the report. This report you have done after the
Lordship, petitioner is not done, Lordship. The responding authorities take the petitioner to the hospital, Lordship, as per rules and regulations, Lordship.
understood, but this laboratory report of Narayana, which was taken into consideration, is page 54. It says blood urine, they have found trace. And come to just turn over the page, RBC, there is a quantity 3 to 5 HPF, which should be less than 2, the desirable range. So where is the error?
There is a Lordship after 124
After the
report,
test,
Lordship.
due to another report where there is no trace.
Another report, next report, Lordship, there is no trace. It means
That report is after holding you unfit.
this is the review, Lordship, review medical examination, Lordship. Review medical examination, in the first medical examination, they have sent to the, again check up for the review medical examination, Lordship. This is the review medical examination.
Where is the review medical examination?
Yes, Lordship.
Review medical examination is of 26/7/2023. This could not have taken into account a report which is after 4:30.
Lordship, here, examine, Lordship, 24, 25, they have given the after 24.
Difficult.
Lordship, similar order passed by the earlier, this honorable court, Lordship.
Similar order will have to be exactly on the same fact.
Lordship,
The
here,
facts are different.
although
Third 3 NH cluster that counts for the petitioner. who had participated in a recruitment exercise for the post of Central Armed Police Force, for the post of Constable GD under the Central Armed Police Force vacancy in F Forward for the year 2022. While the petitioner claims to have passed in all the segments of the recruitment process, he was held to be medically unfit as there were blood traces in the urine and also RBS. RBS. The Learned Council, however, submitted that another test was done on the same date, that is 26/7/2020, as per which there is no such blood trace or RBC in the urine. That notice be issued returnable by 4 weeks. As Guru Alert accepts notice on behalf of all the respondents, that extra copies of the when I take instructions for if on the immediate day he has a report which does not have any blood trace, can perhaps reconsider his case. Because the other he has passed the other thing. Yes. Next.
May I please, Lordship, there is a mistake in the cost title. Lordship, I may be allowed to file a amended cost title.
What is the
Lordship, page number 4, Lordship, the respondent, Lordship, respondent number 1.
1 and
1 and 2, Lordship.
1 and 2, my lord.
Instead of Department of Labor and Employment, it should be Lordship Skill Employment and Entrepreneurship.
Final night.
Yes.
SK Das Learned Council for the petitioner is unheard to SK Das Learned Council for the petitioner, whereas SK Das
For respondent number 4, my lord.
Learning Council present for the
Respondent number 4, my lord. Director of Employment and
Director of Employment Exchange. Harbor for Finance Department and Nature Property. The SK Das Council for the Harbor that is some error in while an error in the cost side and you take file and I for it. Please after a week along with the I that file.
My name may be shown in the process, my lord.
Yes, sir. Yes, sir.
And the name of the Employment Exchange. Director of the effect director.
All right.
May I please, Your Lordship?
Yes.
My lord, matter pertains to engagement in the post of Jal Mitra or pump operator under the Jal Jeevan Mission scheme, my lord. May I go with the facts, my lord, first? My lord, the Public Health Department has set up a pump, water pump basically, in the village of Nahotra under the Morigao district, like any other villages in the state of Assam. Thereafter, under the supervision of the Public Health Department and under the instruction of the Public Health Department, a committee was formed in the local area, a water user committee. And that committee has engaged me as a pump operator in that specific pump. Thereafter, I was continuing from 2013, 26/11/2013. But my lord, in the year 2020, on 15th August 2020, a flagship program was launched by the government of India that is called Jal Jeevan Mission under the Public Health Department.
Thereafter, what happened, my lord? In the year
Are you
2020,
serving, are you serving or not?
yes, my lord.
Hasn't that you are serving?
Yes, I am serving.
Yes.
But the first and foremost is putting a challenge to an engagement letter which has been annexed in the lordship. There is no engagement letter annexed in the restriction first thing.
In his favor.
He said that he's challenging an engagement letter. They have not annexed the engagement letter in restriction court.
Engagement letter of whom?
Engagement letter of the private responding, your lordship. They're challenging that.
My lord, I
Kindly
have
look at the
gravely.
prayer, your lordship.
Yes.
Kindly look at the prayer, lordship. Prayer A says that nature certiorari shall be not be issued, setting aside and quashing the engagement letter dated 6/7.
Now who is looking after the pump?
Pump is looking by the water user committee, which is completely independent body, your lordship. The PH has nothing to do with it. And the engagement letter was issued by respond number 8, your lordship, with the secretary of Manohar Gao
No,
Panchayat.
as on today, who is doing the operation?
My lord,
The petitioner or the private respondent?
That the committee has to say who is taken, because
My
the
lord,
department has nothing to do with the committee. Department sets up the pump and the user water
You were
committee.
paid by who?
my humble submission is that, my lord,
You
the
were paid by
operation,
whom?
my lord, my lord.
You were paid by who?
The water user
Now I
committee.
am not paid by
No,
anyone, my
you
lord.
were paid by who?
I was paid by the water user committee, my lord. But now in the year 2022, a notification has come up whereby the operation and maintenance part has been transferred to the PRIs like Gao Panchayat, my lord. Then what happened? That notification, my lord, have a look at page 43, my lord.
Yes. Now while making the press engagement, where was your case considered?
My lord?
While making the press
No, my lord, my case was not considered, as if your lordship have a look at page 45, wherein it was specifically mentioned that Roman 5, my lord, as page 45, Roman 5. The services of the existing volunteers taking care of O&M activities should be continued, considering their expertise from their service rendered so far. And in case of a new engagement of any volunteers, if necessary, the volunteers may be engaged.
Who will take care of this part? You or the committee?
Gao Panchayat, my lord.
Committee will.
As Panchayat. Mr. Dekka has referred to this clause 5 at page 45.
My lord.
So we had a query that was there any requirement for considering? Now, was it considered? That was our question. In fact, there is a requirement of considering. Only because of the fact that first is serving for long, and number two has got sufficient expertise. You don't need to engage a new hand, train him up. You are already having a person with.
Already I have rendered training also, my lord.
Yes, my lord. First, my lord, he was appointed by water user committee. My lord. It's not a government committee, my lord.
No, those parts we are not. We are not entering to the dispute. We know that his engagement, his interaction,
my lord,
cannot be proper. Or at that time, what do? Somebody has to run the pump.
Yes.
They have made some arrangement. They are paying from their own.
My
That is okay.
my lord.
Now, when the stage has come to formalize everything, there is a requirement under the procedure that you consider the cases of persons who are already in the such activity. Did you consider?
Whether his name was forwarded or not, that I have to take instruction. Because first he
Are you working?
My lord, yes. Till that I am serving that pump, my lord. But the person who has been allegedly engaged, he is not there itself, my lord.
Where have you stated?
My lord, in para. Paragraph 11, my lord. That the petitioner begs to state that immediately on the next day, that is on 19/5/2023, the petitioner, along with some, may I read from the earlier para, my lord.
No, you said you told the statement where you said as on the date you are serving your earlier paragraph we have read. You're not finding that it.
Paragraph 11 also may be read, my lord.
Yes. My lord, paragraph 11, that the petitioner begs to state that immediately on next day, that is on so and so, The petitioner, along with some concerned residents of Nohatra village, went to the office of the Monoha Gao Panchayat, wherein
Village 7 is not relevant. So that guy should come prepared. You come to page 50, paragraph 50, third, three, Decca. Then it comes for the petition who is aggrieved by the action of the respondent authority in engaging the respondent number 11 as the pump operator for the Nohatra NASCR EWSS. Full stop. This is the case of the petitioner that the this is Monoha, it's called Monoha.
Monoha, my lord.
Mono?
Monoha, M-A-N-A-H.
The Monoha Nohatra Water User Committee by a resolution dated 26/11/2013 had inducted the petitioner to work as a pump operator at a monthly remuneration of rupees 2,000. The petitioner has claimed that he is continuing till date the same capacity. The petitioner has also submitted that in the month of November and December 2020, he had undergone a training on the state operation and maintenance. However, on 18/5/2023, certain official had come and tried to out the petitioner from the state engagement by stating that the respondent number 11 was newly engaged as a Jal Mitra. The United Council has referred to the order dated 9/2/2022 on the activities to be undertaken by the implementing agencies, which include serial number
30, my lord. Oh, one.
serial number A within bracket A within bracket small 5 pertaining to supply of drinking water, rainwater harvest and water recycling, that services of the existing volunteers should be continued considering their expertise, and this aspect appears to have been overlooked while making the present arrangement. Para issue returnable by 4 weeks, as Dr. Standing of PNR except we have responsible 1 and 2.
1, 2, and 8.
1, 2, and 8. Whereas R. Gokul, standing of PH except we have responsible 3,
3, 4, and 5.
3, 4, and 5. CS Hazarika, State Council for responsible 6. What about 7 and 8? 7, 8, 9.
These are president, my lord. Notice as to
Let extra copies of the
7, 9, 10.
7, 8,
of
9,
the
10.
writ petition be served
8 now.
on the Senate Council for the
7,
respondent.
9, 10.
That steps be taken for service of upon the respondent number 7 to 11.
7, 9, 10, 11. 8 I may pick.
7, 9, 10 and 11 by registered post meeting, except by Monday. Three Decca. The learned council prays for order. By referring to the amendment made in paragraph 15 of the petition, the learned council has submitted that the petitioner is continuing in the state capacity as compensable. Yes. Consider the support certificate and the fact that petitioner is working state capacity for more than a decade, the present arrangement by which the petitioner is rendering service as compensable cannot be disturbed till the return. It is also observed that the demonstration entitled to by the person by dint of his service.
Highly obliged, my lord.
The aforesaid interim order, however, would be reconsidered after obtaining instruction by the council.
Much obliged.
Yes, next. APTCL.
APTCL. Well, this is a case of compassion appointment. If you lordship go through last
You have
order.
scheme for compassionate.
Yes, my lord. 2014 scheme, my lord.
You had.
We had.
As of today,
It's as of today we have going to adopt the new scheme as per the government policy. But he's under the 2014 scheme. So my lord, this matter can be disposed of if my friend agrees. Let them give a representation.
Not your friend. He's a senior.
My senior, my senior agrees. I apologize. I was if a given a representation and press consideration for the against the vacancies that's available for the. No, press consideration means that you have to apply before within 2 years. That the rule is there. If
No,
I
he's
have to,
making a concession that embargo will not be adhered to if you apply. Your application will be considered.
but subject to the objection must be there that there is a still vacancy. That is the point. Last time also same thing happened.
No, if there is no vacancy, where will you be?
No, last year, that's why they have what we have got an affidavit, madam. We have filed an affidavit. As per affidavit shows that there is a vacancy.
There is a vacancy.
My lord, what had happened? There were 47 vacancies as well there, out of which 15 have been recruited, and out of that the rest are remaining. So he has applied for that, but it was not considered at that time because of the financial package that he had received from the department. So, and as per the Supreme Court judgment, he was rejected. So we have filed the affidavit accordingly. But however, as per the telephonic instruction that I have, we may reconsider his applications along with the force, and the department will consider if they can fit within the compassionate appointment. No, that is fine. That is fine. But thing is that
More will you get? Third. Petition. Whereas representing the APTCL.
1, 2, 3, 4.
The state respondent.
No, the private respondent, ma'am.
What the private?
Because they have why I make them private? Because they are the person who was selected. My name was not there. They are the person who was selected.
They've been served or not?
Notice has been served. Okay.
Served.
Sir. I think private. Oh, what my junior said that there is, in this case the notice has not been issued by earlier order, because then they don't this court doesn't find fit to issue notice. I think this is necessary because.
Yes, sir. See, earlier rejection was because of the financial
Yes, my
competition.
lord.
Now, that part you will, how do you treat that part?
My lord, that has to be left with the authority to decide, because my lord, because there are 47 vacancies that was been left.
No, it was not, the rejection was not because of want of vacancy.
Yes, my lord.
The rejection was on a comparative statement of the financial capabilities. Now that factor is still there.
Yes, that fact is still
Now,
there.
if you remand the matter,
Yes, my lord.
and you reject it on the same ground, which is the subject matter dispute, not serve any purpose.
Absolutely, my lord. So they can be
Unless you concede that this financial comparison,
my lord.
that element will not be a part of the consideration. No purpose will be served by.
Absolutely, my lord. My lord, as per the instruction that I have, because there are 47 vacancies that are left, so the application which they gave on 2014, because my lord, there are 126 applications that were there. So whether the petitioner will fit in, that cannot be regarded, but other people who are there are other petitioners also. So that can be taken into account. Whether only the particular petition number 1 is there, that will not be significant.
No, Mr. Sharma, I think closing this petition may not be a very fair procedure. We can do one thing. We keep this challenge open in this petition, and in the meantime, we say that pendency of this case cannot be a ground for not considering his case for the remaining. See, this is the.
I absolutely understand.
This is a factor which will be available on each of the considerations, and it is a relative fact. Tomorrow, today he may be financially well off than his other competitors. Tomorrow there may be others, and he may still get the job.
My lord, his only account that he was not, he has not been selected. We did a committee and I brought the record also, and even in the affidavit I've said it. The only ground of his rejection was a financial factor, as my lord has
And
pointed.
exactly, that is the rejection.
So my lord may then.
That rejection, the reason which you have assigned for rejecting is the subject matter of dispute.
Yes, my lord.
Which we like to have to adjudicate, and in that case, hearing the other private respondents would be necessary. Now, if we make an observation that while this will remain pending, there will be no bar
for
consideration of his case in the remaining package.
My lord.
Where there will be a fresh consideration vis-a-vis the other candidate.
My lord.
And this consideration of yours will not stand in a way.
My lord.
If he gets it, balance would be becoming first. If he doesn't get it, then
My lord, I agree on this.
That is the course which will be the best to, and that will not cause any prejudice.
Yes, ma'am. Yes, yes. So I should give it an opportunity to file an application.
Yeah, we will do that. The ground, the ground of challenge, the subject matter of challenge is the rejection of the application of the petition for appointment on competition ground. It is not the bar that under the earlier scheme from such appointment were permissible. The rejection, however, is on the ground that on a comparative assessment, the petitioner was found financially better off than the other candidate. Sharma, turning on activities, however, has submitted on instruction that that initially there were
120 for one amount of
that total vacancy were
47.
And in the first round,
14 were selected.
how many?
14. 14 were selected. My lord. Remaining 20.
And 14 numbers of candidates were selected for a and therefore there are still.
But another point I want to this is he is a gate 3 employee, and there are it is a combined of gate 3 and gate 4. So gate 3 is I think 6.
And as of today, there are 33 numbers of vacancies, right?
47 minus this one.
33 numbers of vacancies.
Vacancy including gate 3 and gate 4.
In grade 3 and grade 4. Sri Sharma, the Learned Council, has further submitted on instruction that the petitioner's case may be directly considered while filling up the remaining 33 vacancies. As the as factor of comparative financial position would be a relative one. Considering the this court is of a considered opinion that by this petition maybe by this petition may be kept pending, and the interest of justice to be served for direction for a fresh consideration of
41 remaining
the remaining 33 vacancies. The petitioner is according and he would to submit a fresh application, not submit an application along with a copy of the order to have his case considered afresh while filling up the remaining number of vacancies.
Well, that I want to point out. I just gone through that annexer they have filed in their affidavit. If you have to go through your affidavit, 81 page number 81. There are grade 3 posts. There are 1, 2, 3, 4, 5. 6 has been appointed. That means 47 minus 6. 41 vacancies there, not 33.
Oh, we are saying grade 3. You cannot have a rigid thing that you will be grade 3 only.
No, yes, if you have to go through the page 75.
Your choice can be grade 3 or grade 4.
Yes.
But it cannot be a matter of right.
No, not a matter of right, but I just pointed my lord.
You can file an application.
Yes.
Finally, contemplating to hold the selection.
My lord, that instruction I don't have.
File it immediately.
File a time bond may be given, my lord.
No. As and when they fit up, we cannot just ask to fit up. We have kept this pending. Next.
Lordship, I have received the instruction, my lord.
What is the matter?
That matter.
It is fixed today for instruction.
Oh, that
Yes,
MSCP matter. Gradation list.
Yes, sir.
Yes, madam.
Files are not traceable.
Huh?
The files are not traceable, my lord, after 2000.
Files are not, that is the instruction.
But in the record, Lordship, index record,
Council is traceable.
the file index record, it was last moment was up to 2006. The relevant portion is also annexed.
Thoroughly searching this department, but the file could not be traced. As per file index record, the last up to 2006,
Lordship.
My lord.
no movement is seen thereafter.
Lordship, I have made a statement that they have informed me that since I was not appointed by the DTO, my service record is not present with the transport department. I approached them.
No, the file, there is no record
of
of
that.
file movement. How do you tackle this matter?
My lord, only thing subject to as an officer of the court. The advertisement was one, my lord, wherein all this subject to, because I have also not seen it. Appointments that were made, my lord, there was no separate category being. It was by luck that he had come into this post. If that be the factor, my lord, whether the subsequent denial would be
No. That part we are not even, don't have any doubt regarding his entire. How do you resolve the?
resolve the issue, my lord, this post being within the permit purview of the office now, because it's MACT and district judge, they are one person. Within the purview, my lord, without even going into that, my lord may direct that because he's already recruited through a same selection process, the seniority be maintained according. Rest, my lord.
In which establishment?
In the establishment of district judge, my lord. Because this post is an isolated post, my lord, created for that MAC. He came into that by virtue of maybe luck, my lord, or ill luck. That's my understanding, although my instructions are, my lord, different.
What is your age?
The petitioner is
Dictionary is
56 or 57 years as of date.
56 years, 2250.
You were inducted as what?
LDA.
LDA.
Remained as LDA.
Yes.
Still as LDA.
The others who are there in that appointment order, my lord, their name.
What is the adverse consequence if you have your name does not figure? Reticent is for the purpose of considering your promotion.
Promotion,
etc.
Will not
Your
be-
promotion is due or what? Is that the consideration or is there any other?
That's the only consideration.
You are right for promotion.
Yes, yes, sir.
Otherwise, post-retirement benefits are not. I don't think
there will be no
Will
issue.
be no-
you have to be treated as an that code for our purpose. Because treated by the department
Will
not him. Who is paying your salary?
As per the affidavit, lordship, it's being paid by the transport department through the district judge. I'm receiving through the district judge office.
No, not who is paying? Who is paid? The payment, the monthly salary is paid by whom? Transport department.
No. There is no such thing.
Okay.
You are
No,
getting
no.
two salaries.
From the district judge
One for
establishment.
district judge, one for transport department.
From the district judge establishment.
So now,
My lord, that instruction, I can have it, my lord. I think that would be vital.
what is fiscal? District judge having a head from which his salary is being
Distributed.
coming.
Should not have happened.
That is a very minor issue.
If your lordship can
You
have
have
it,
that instruction.
I'll have that instruction. My lord will have it next week.
Even if it paid ultimately come from transport department, that is not
Different. It will be, my lord, the recruitment is made by the district and assistant judges.
and this post is not personal to him.
No,
He was
Somebody else-
transferred.
it's a post available in that establishment for you. If I may put it through.
person to the order date 17/8/20 of court. MSFD Board of the Standing Council, Transport Department has updated instructions as per which the case record as per which the original file pertaining case had could not be traced out. As there is no trace, as there is no as no movement of the file is seen after 2006. You can add representing representing the
District and
district and judge is directed to have the instructions with regard to instructions as to from which head the petitioner is being paid his monthly salary.
And who is the DDO? Who is the disbursing? Drawing and disbursing.
And and also the concerned DTO for petition.
Lordship, I'll get.
Is this case after 2 weeks?
My lord, this is August, hello, September, my lord, first week,
Is this case on
7th or 8th.
11th of
Lordship.
Eleven.
Lordship. Much obliged.
Another part.
this one?
Uh,
You want it back over?
I have
The written instructions dated. What's the date, madam?
Lordship, I have taken print out the digital signature, Lordship. The 23rd of August, my lord.
Written instructions dated. Uh,
28/3/2023.
where do you get?
Lordship, because it's signed digitally, my lord. So
Where is it? Wait,
just sign. I will give it another copy.
a copy of the written instructions is made part of it.
I'll provide another copy.
Doesn't matter.
Here, my lord, we have sent the affidavit for swearing and vetting. Lordship will kindly give me 1 week time, my lord.
You need a week time for
My lord, to file the affidavit.
affidavit.
Yes, we have already sent it for swearing and vetting.
Let him file the affidavit. Third, please see the concept for the petition. Para, they are purposes that the sending concept by however submit that the affidavit is ready and we filed out. Para, please after a week.
Yes, then may I leave?
Tell us the date which date is convenient for you. Tell us whichever date is convenient for you. Based on, as requested, based on.
September.
11?
Yes, Lord.
11 September.
Obliged.
WPC 1989 may kindly be seen, madam.
1989.
89.
Yes.
Order dated 31/7/2023, your lord. 1989, order dated 31/7/2023.
Yes.
Yes. My lord, this, your lordship may kindly see that order. Particularly paragraph 7. Okay.
Yes.
Then your lordship will kindly see paragraph order dated 14/8.
Yes.
14/8, your lordship. My lord, now present position is, my lord, today they have filed an affidavit, whereas board. In my humble submission, completely false affidavit by the managing director, saying that the petitioners are working in sewerage board, municipality. That is incorrect. They are working in sewerage board. They are not getting any salaries.
Who is for this sewerage board?
Sewerage board, they, my lord.
You have filed a
Yeah, they say, my lord, they will pay their, my lord, earlier salaries, where as and when the finance department clears it. And regarding the present salary, the Silchar municipality board will pay. They are unable to decide the matter.
SMC.
Central board.
SMC. What is your stand? Are they your employer?
Lord, it's a very in a confusing manner, my lord.
It's
How many of you are there?
My lord, in my case, my lord, it is 34 employees.
Madam?
Their cases, my lord, they are getting salaries.
Our case is different because we are working.
Urban.
Here also, we are also urban, but government has framed a scheme saying that, my lord, Your lordship will kindly see that page 106 of the writ petition.
106.
This is the letter to the executive officer, Silchar Municipality Board. With reference to the subject cited above, it is directed by the government-wide order under reference to hand over all water supply schemes maintained by Assam Urban Water Supply and Sewerage Board to respective ULB. In view of the government order, the man and materials along with liabilities of Silchar Municipality Board scheme has handed over to Silchar Municipality Board. The amount of revenue already collected in the account of Managing Director, Sewerage Board
Where are you
amounting,
reading?
page 106, my lord.
Annexure 3.
Yeah, Annexure 4, man.
Seven.
Yes.
Annexure 7.
Has your lordship seen that?
Yes, 107.
And thereafter, my lord, that page 109.
Yes.
In pursuance of the decision taken in the meeting chaired by Honorable Chief Ministers on 14/5/22, the Assam Urban Water Supply and Sewerage Board will partially hand over the running scheme to the urban local boards, and concerned ULB will bear the cost of electricity, chemical and maintenance bill of such schemes from the available
Now, what is
fund.
your?
Now they're not
you're-
getting salaries.
You're not getting salary.
Not getting no salary from January 23 till date. No deduction of CPF, no deposit of GSLI, and salary paid for the month of.
Yes, how do
no
they-
salary from my lord. This
how
is
do
the
they survive?
And your lordship has
How
advised
do
the
they
matter.
survive? Yes, who take responsibility?
Salary. The board has already sent a budget.
You're for the Sewerage Board.
Sewerage.
As per your affidavit, they are in the services of whom?
We have verified in the last petition also, we have submitted the affidavit in opposition. It has been mentioned that on, I'm just reading this particular paragraph, Lordship, that the Silchar water supply scheme, which was handed over to the Silchar Municipal Board on 14/3/2022, was implemented under the NLCPR, and it is not under the OMRUT as stated by Auditor Sergeant Sir. As the scheme has already been handed over to Silchar Municipal Board, hence the Silchar Municipal Board will manage the payment of salary and other emoluments to the staff with effect from 15/3/2022. Now, with regard to the previous one, Lordship, it has been mentioned that prior to handing over, that is on 14/3/2022, the board will bear the past liabilities of handed over of staff subject to receive the proposed one-time assistance from the government. However, the SMB will take the responsibility.
Mr. Chaudhary,
Yes.
May not be too much concerned with your statement here. How is the problem going to be resolved?
Lordship, this
Isn't it a fact?
finance department, some sort of instruction is required to be obtained from the finance department.
How see, they cannot be left high and dry like
Exactly, Lordship, exactly.
They are serving their charging their services, maybe under the Sewerage Board or the local body. But it is a fact. It's not a dispute that they are discharging the duties. Now they have to be in the period where there is a transition. If somebody has to take a call, finance department, how to tackle the situation?
Just file an affidavit there with the petition is that. But there, the executive department, they under that part of government. Then
Housing and urban. Housing and urban. Sana, you are there.
Lordship, on last date, a specific direction was given as regard who is the appointing authority, who is the disciplinary authority, and who will pay the money law. In terms of that order, Lordship, a meeting took place between the concerned bodies, Lordship. And ultimately, a para-wise comment has been furnished to me, Lordship. Now, it has been decided that dues prior to handing over, Lordship, will be the responsibility of the Urban Water and Sewerage Board. After handing over, it will be Silchar Municipal Board. Now, Lordship, this.
Now, when was it this particular thing handed over?
It is mentioned there, 15th Lord.
But they are not getting the salaries since January.
But I'm making one statement very clear, my lord. Although all this handing over things have been done, but for all practical reasons, my lord, they are working with the CRS board.
No,
They are functioning
that is
from
no
there.
lordship. That is,
No, still
they are
municipal board
working,
rules.
they were earlier also, they were under a scheme lordship. Now also,
No,
they are,
Mr. Das, we
We are
will not
interested
go
in
into
our
this,
salary.
right?
those are different issues.
We are
Lordship will-
interested, we are concerned with your
Your
salary
salary
part.
only.
Party. Whoever pays, my lord,
Whoever
should be
may be
paid.
your employer, there should not
I've
be
given the
any,
chart manner from which
there should
date
not
we
be
are not
any
getting.
adverse condition in your working.
Yes, yes. We have no complaint, my lord, wherever they are making us clear. But
Now
your
they are
lordship
not
will
getting
condition.
salaries from January 2020.
Yes, sir.
You said that March, till March, they were under the
20
storage.
22. 22. 22.
Huh?
22.
No salary from 23 of the
No,
January.
The date is mentioned there,
Salary paid
lordship.
from June 21, that chart I have given, my lord. That one page letter, my lord.
And why number 4, no salary from January 20?
Yes, no salary from January 23 till date. Again, my lord, no salary, number 2, your lordship will kindly say, no salary paid from June 21 to January 22, 8 months. Salary paid for the month of February 22 to December 22, 11 months from the fund of
No,
sewerage.
that, that 8 months from June 21 to January 22 is an arrear. That
8
is-
months, yes.
But now from January 2023, you are not getting salaries together.
Yes,
Presently also.
yes, yes,
But the taking over, handing over, whatever it is, it was in March.
yes.
So till March, Suarez board has to bear the responsibility.
Whatever they decide, my lord.
And after March, from April, is municipal board.
Municipal report, they say they do not have funds.
No, that,
Not
that is not-
only problem, whatever revenue is coming from the scheme, there is a great amount of
Third of
deficit.
March.
Now, therefore, my lord, unless the fund comes from certain areas, the lordship is aware that it should come from the finance fund. So that is the whole thing. My lord, so far under the scheme, the Silchar municipality has taken it, but your lordship may kindly see my affidavit at page 129. What is our position?
Then again, it come back to Mr. Porpujari.
Hello, can I take your lordship to that?
No,
part?
just Porpujari is the head.
Let the affidavit, my lord, be filed by the Department of Civil Affairs, because the modalities will have to
These
be
are not
worked out.
matters of affidavit. These are not matters of will go to a pleading. You are not disputing that the petitioners are working for fun. They have come to this court not for fun. They have
They
not
went
got their
for
salaries.
picketing, my lord, they were
In
arrested.
the stage of transition, 1 month, 2 months here and there is okay. But you have regularized now from January to August, they are not getting salaries.
No,
Even last year 8 months salary still awaited.
so therefore, my lord,
Now, municipal doesn't have fund.
understood, my lord.
that statement is not correct. On last date also, fund is one document,
Municipality has got funds.
not municipality. The scheme under the scheme itself, lordship, they have their own source of revenue. That is the position, lord. Lordship may kindly see that second page, lord.
By this Silchar water supply scheme,
Yes, lord. Lordship may kindly come to third page, lordship.
now this water supply scheme is operated through whom?
Under municipal board, lordship. This this scheme has their own source of revenue, lordship. In the first page itself, lordship will see.
Mr. Ratta,
No, actually,
Because that amount of shortfall there.
So,
My lord, if it is correct, there's no problem.
the lordship may, and the third page, lordship, lordship.
And it's not a high.
No,
Now, what will happen, your lordship? So the moment it shall not be able to pay, so the other side will come up with a contempt. So it will logically take it, will come here. What poor man cannot do anything unless there is fund. That eventually lordship.
Lordship may kindly come to third page, lordship.
Necessary. Get the fund.
the total balance is minus in third page.
Third page, lordship may kindly say January 22, January 23.
Page?
Page third page, its pagination is not there, but it's in the third page, lord. One table is there.
Yes.
Serial number 11, lordship.
Lordship may kindly see the figure January 2023, 18,60,000 Lordship. The next one, your Lordship will see February 23, 9,06,000. So these are the earnings from the same scheme itself, Lordship. And the total amount of salary amount is required around 9-10 lakh rupees per month. Now, where the fund has gone, Lordship, it has gone to the municipal fund. They have utilized it somewhere else, Lordship. Instead of giving salary to the employees, if it has been used in some other purposes, Lordship, where from the employees will get salary? So that is the basic issue, Lordship. Deficit may be there, but it has its own revenue source, Lordship. And in the first phase, Lordship, one calculation is given there, Lordship. In the first phase itself, Lordship. Lordship, may kindly see one, serial number 1. Total house connection is 2389. These are existing connection, Lordship. Billing household 2389. At the rate of Lordship 450 rupees, Lordship. 10,75,000 is the monthly income of this scheme, Lordship.
Yes.
So where that amount has gone, Lordship? So these are not hypothetical situation, Lordship.
Collection, what about cost factor?
This is the maintenance comes from 15 Finance Commission. Electricity comes from Finance Commission, Lordship. Only the salary portion is to be bared by from this income, Lordship. So everything cannot be shifted to the government, Lord. It's ultimately this is a scheme. Lordship, that will be.
But we don't want to suffer.
That is only thing Lordship will pass a direction to the municipal board after looking at these figures, Lordship.
That is why
With a specific direction,
that
Lordship.
is the reason we
Yes,
want
Lord.
this after effect. We want to that.
Well, I clarified this chart. Lordship will look at collection March 2023. 1,30,900. Then you Lordship again July 2023. Now monthly payroll where we at
Reason will be explained by them only, Lordship. I have given the figure. 10,70,000 is the earning. If they are unable to earn,
How much is your salary?
salary I am told 15 lakhs.
no, Lordship. That is not correct.
Okay. Don't they know?
Let them say by
Don't
giving
they know
affidavit.
like this? They come up with your breakup. You come up with your breakup. How many employees? there?
Right now,
33 was 30. No, 34. Here in this petition,
But they are not working with us present. That's the reason I say everything in a country. And ultimately you lost find there is not salary collection. And therefore unless there is no debit fund.
Now, how do you immediately have a request of the
the last occasion when the matter came up,
we
my lord,
can sort this out.
Honorable Justice Mallard Surana, my lord, it came into the picture that let it be chaired by the Chief Secretary along with the officials of the court and let them find out the story.
But has it been done?
No, it was ultimately my friend said, my lord, it has been already done. So if it has been done, my lord, it has to be done in presence of all the concerned officials. And I do not know whether any resolution has been passed because the proposal from the court was that let it be chaired by the Chief Secretary along with the concerned officials.
Which order?
My lord, now ultimately, my lord, my friend said, my lord, it has already been done. Yeah, I think it will be reflected in the order dated 23/8, 14/8. 23/8. 23/8, I think. 8, I think. 14/8. 23/8 order, your lordship will kindly see. No, not sorry. My lord, 31/7/23.
Yes.
There, my lord, your lordship will kindly see para 7. Copy divana. It is provided that in the event no affidavit in opposition filed by the respondent, if there is no clarity in the stand taken in respect of authority who will paying salary to the petitioner, respondents are put to notice that on the next date of listing, orders will be passed for personal appearance of 4 authorities on whom notice has been issued with regard to salary of the petitioner. Already, Malad, this notice has been already put. They have to sit together and find out, Malad, this is, Malad, the way things are being done, it is not looking good. And thereafter, the order was passed on 14/8/23. They have to sit together and take a decision, and come back to your, they will have to present a resolution before this court. They are not doing anything despite the order of the court.
How soon can I put this affidavit? Find this affidavit?
Lordship, these figures we have received from Urban Water Supply and Sewerage Board. Let them put these figures in an affidavit. Lord.
How soon?
Yes, household is 2389 number.
And how soon can you find it? How soon?
If we got to get it.
Within 1 week. Salary matters. We don't want to prolong.
But in
Once
the
we have the
meantime,
affidavit,
let them be paid some amount from some source. Let them survive, my lord. They went for picketing, ultimately they were taken to jail. They will have to survive, my lord.
okay, next affidavit pass. Let them fight.
Some amount of money unless.
Let them fight it. Pass.
My lord, your lordship may fix the date.
No, but that will not. You can file the counsel, but that cannot be a reason for delaying. Therefore, it's grant the service.
Can see or one department is told to other and all are we can not know what to do.
Yeah, I'm only submitting the pen of the document.
On the next step, we'll have the decisions of the current synagogue.
AG, man.
Not AG, but the AG, that synagogue.
Lordship, even the Advocate General is also aware of this method. If they have been, authorities.
If he comes, my lord, it will be better to sort it out.
If the case comes, if you think that he's present, but you can have him also. But we'll have the an order for present.
The lordship may pick the matter next week on Wednesday or
Next
Friday. Friday.
Third.
Monday.
Three. Also heard. Who's the appearing as Dr. for Sister Municipal Board? Sri Nayak for
1 and 2.
Who are
It's Housing and Urban Affairs.
Housing and Urban Affairs. Our board finance.
Finance for R9. That's
No, not 26 finance. Chaudhary for don't the numbers. Assam Urban Water. The primary issue is with regard to non-receipt of them by the the period concerned is one where the operational activities are transferred from the urban and water supply and board to the local bodies, which in this case is Municipal Board.
In my lord, 1989.
Others
we have not yet picked on. We are still
This data is by who? You or
me, Lord.
The Nayak, the London Council has, however, submitted that the responsibility for payment of that till the date when the operations were transferred to those to the local urban of the various board. and after such transfer is of the local urban body. He has also placed such data of the furnished by executive engineer of the AUWS S board, Barak Valley division, to show the income received by way of water test and submit that the scheme itself provides for generating income from which the salaries of the concerned officials can be paid. On the other hand, company as the senior counsel representing the intermunicipal board has submitted that there is third of month as a result of the salaries are not being paid. It is not a dispute that the petitioners in WP 199 of 20 are not getting their salary from January 2020 and even for even salaries of earlier 8 months from June 2021 to January 2020 have not been cleared.
The CPF etc. are not being deposited anywhere, man.
It has also been submitted that there is no deduction of CPF and the other statutory deduction, and therefore there has not been a deposit. And let this case be listed. Let these cases be listed on Friday next.
Will be a bit difficult. 31st and 1 will be difficult. May take up this around 38.
30.
Yeah, it is fine.
Wednesday. Where have we got first?
First lot I'll be out of.
Then 31st.
31st also. So that is
Can you file it immediately?
I
It's
can
up
file
to
it.
you.
Not if I can file.
But the-
One affidavit I will one affidavit will come from the storage.
No, as requested by Sri Nayak, that this case be listed on 30th of August, by which time the affidavit got filed. On that date, this court will also consider passing direct with regard to current salary of petition.
Not only farm salary, area salary has to be paid. You will
No,
have to
at least
survive.
current salary you can survive. Area
That order is already there, man. We are not seeing some. Last order is there already. I'll show. I'll show on the next.
There is a order, my lord, 7586.
interim order. That last part, why did it do that? We are not reiterating an order. If it's not being complied, it come up to the court.
No. I mean, they were, like, who is going to pay? Question is,
No, last
मतलब,
time I could give us. Interim order passed at it. If any.
7586, 22 and 3263, 20.
Interim order passed earlier. WP
7586, 22
and
3263, 20.
3262. That complete the next set of options.
Well, they will have to give a concrete suggestion before the court as to who is going to pay the salary.
We can also explore that option of having a meeting.
Yes, that is the best thing because
There is already a meeting with the chief, headed by the chief minister. There is already a resolution that in the interregnum, the board will pay the wages. That was recorded in the last order, and they were supposed to pay instant.
Board means you.
No, this case is different, Lordship.
Say-
Their Lordship,
say
it has
court,
been handed over, but in their case, Lord, we yet to be handed
there
over.
is an interim order.
Lord.
Oblige.
May I please
Yes,
interrupt? Worship, this is compassionate appointment, my lord. My case is recommended by the DLC, my lord. And SLC rejected my case, my lord. Impugned the speaking order is on page 25, my lord. My name is appear at serial number 22, my lord. Next page, my lord. Nazir Ahmed Talukdar, my lord. Ground of rejection is, my lord, not within the 5% quota and already filled up, my lord. Second ground is, my lord, underqualified, my lord. Worship, my case may be considered as per clause 15 of the office memorandum dated 1/6/2015, my lord. Clause 15 says that if sufficient vacancies are not available in any particular office of the office to accommodate the persons in the waiting list for the compassionate appointment, it is open to the administrative department office to take up the matter with other department office of the government to provide an early appointment on compassionate ground to those in the waiting list matter. First, my limited prayer is that SLC may be directed to consider my case as per clause 15 of the office memorandum letter.
you are supposed to have instructions.
Lordship, I have not received any instruction, Lord.
So last order, 26.
Yes, Lordship.
What was the instruction? It was the court was considering.
Lordship, basically up to date status of the vacancy position.
Honorable Court also passed similar order in respect of serial number 23, my lord.
Where is the rejection?
Rejection, Lordship, page 26, my lord. 25, annexer 825, my lord. My name is at serial number 22, my lord. 22, my lord.
Your Nazir Ahmed Talukdar?
Yes, my lord.
Underqualified.
And,
You're underqualified.
yes, my lord.
Then,
as per my educational qualification, my lord, my case may be respected, my lord. Serial number 23, my lord, already appointed, my lord. He was also rejected on the same ground, my lord. This honorable court passed direct considered this case, my lord.
now if you're underqualified, how will you be appointed?
As per my qualification, my lord, my case may be considered.
What is the qualification necessary?
Next page, my lord, speaking order. Next page, my lord. 27, my lord, page.
Yes.
Second paragraph, my lord. This is also speaking order. Whereas after recommendation by the DLC, Nazir Ahmed Talukdar candidate was placed before the SLC state level committee in its meeting held on 19/6/2018, but SLC rejected the candidate on the ground that the candidate does not possess graduation degree as per the Assam register.
Now, what is the minimum qualification which is prescribed?
Graduation.
If you are having education, how?
As per my qualification, my name.
No. If you are saying that the minimum qualification is graduation.
Worship, I applied for the grade 3 post or grade 4 post.
In grade 4, what is the essential qualification?
Class 10 HSS.
You have that qualification.
I have, my lord, HS.
Do you have the qualification for grade 4 or not?
Grade 4, I have, my lord. Grade
You
2
have?
also, my lord.
Yes, so how you can consider him for grade 4? The underqualified person cannot be
Yes, ma'am.
appointed
Yes.
in post of LD, which was the graduation. Graduate degree. Now he have said that he says that he is HSM, which is I think will need for a grade. You
Yes,
can
ma'am.
consider for a grade 4.
Yes, ma'am. As per my qualification.
Your higher secondary pass.
Yes, my lord.
Yes, what to
Yes, Lordship. In any other post.
Cost 15.
Cost.
your SPLS third.
HLS, ma'am.
Third HLS third. Third conflict for the petition. Also heard. Chaudhary for
1, 2, and 3, Lord.
department
PWD.
public court. Also heard to be concerning of public court department, whereas as well as well he as other state considering the subject matter involved common and as agreed by the party. The is disposed of at the subject matter is of consideration for a person on completion. The protected case of the petitioner that the mother of the petitioner, Noor Khan, was a grade 4 employee in the office of the PWD Rural Road Division, Hailakhan, and had died in her name on 17/2/2012. Under scheme for appointment of operation and ground, the petitioner had made necessary application. Whereafter, on 12/11/2014, his case was recommended by district level committee, Hailakhan. However, the state recommendation was not considered by state level committee, for which the petitioner had earlier filed WP 644 of 2000, which this court had passed and ordered it 10/5/2009, direct for consideration of case of petition. Thereafter, Sri Lanka Dillon Council was petitioner has submitted that the state level committee in 1996 while considering the petitioner, while considering the application of the petition, had rejected it on two principal grounds, namely, one, he is not there is no vacancy within 5% quota, and number two, the petition is underqualified. But the 18th why are you telling me now? In order.
Earlier, I approached this honorable court seeking direction to consider my case, my lord. Honorable court disposed of the reputation, my lord, on 2019, my lord, in the year.
It's a wrong direction. There is already a
Honorable court directed if not considered earlier, then
uh, there are court that so the has submitted that from the speaking orders passed pursuant order of High Court dated 10/5/2009, it should be done that the state level committee had already had a meeting, on 19/6/2000, in which the application of the petition was considered and under para. The learned counsel has submitted that though he may not have the, though the petition may not have the quality to be considered for appointment in any grade 3 post, this he is higher secondary pass, he has the quality to be considered for any grade 4, which exercise does not appear to have been there. Both Sri Chaudhary, the learned and Hadalika, the learned are not opposed. The proposal to the proposal of the court to have a fresh consideration of the case in any grade 4 vacancy, which may be in view of for fact though no fault is attributed to the assembly for rejecting case of the petition as the ground for third rejection found tenable, the assembly is directed to make a fresh of the case of the petition for appointment of professional ground any grade 4 which would be compensated to the education department of the said exercise the next meeting of the assembly whenever it
most of like.
Okay. Lordship has said that any grade 4 post, so it will be of the department of cross.
That we are not saying. One is your up to how you implement it.
Most of like.
Rest any urgent matters. Mr. Sharma, you are waiting for long.
Yeah, my lord, item number 43 on the last occasion,
Geology
lordship.
and mining matter, but I'm appearing for the respondent number 3 today this time. I'll require 2 weeks time. Now, my instructions are there. I'll file my application.
We also require the time to file.
Actually,
the tire for
I'm for the respondent number 3, the
Your
person in
but
charge.
Lordship had called for instructions from the government, that is respondent numbers 1 and 2. His appointment I'm challenging, but more important is the instructions from what the government submits.
My lord, there was that rule. That rule was not being followed. And my lord, ICS officer, I'm an IFS officer now. ACS officers and IFS officers were being appointed. Division bench said nothing doing, you will have to go with this. Now they have come out with certain reasons, my lord, some instructions have been given. I'll try to place that on record. Otherwise, my lord, the matter, the government is also gone up on review for the division bench order. I'm not sure whether the matter would be entertained, but that is also parallelly proceeding. So if my lord can have it immediately, my lord, say after that vacation, we have 3-4 days vacation. After that, if your lordship can have it, I'll immediately file my affidavit.
We have also got the Paravas comment, your lordship, we also require that same amount of time.
You are a deputy director.
I am the chief
Senior-
drilling engineer now. As per the rules, Lordship,
You have the
eligibility to be promoted as director. I'm the senior most now in the department. The post of director fell vacant in the
Today
year.
will not have the time to tell us. The marriage break was right. Let him file the affidavit.
Yes, let him file in case the more relevant will be what the government submits.
Item number
Item number 43.
third page for the also heard the as other candidates
1 and 2.
whereas you can understand
For
has
respondent
appeared for the private respondent number
3.
both student council respondent submit that they would be filed and has paid for as agreed to by the party. This not
My lord, the week starting from 11th, any date, my lord.
on 12th
Lordship.
Tuesday, which I
Yes.
write this.
Lordship. I'll have my affidavit before that. Much of it.
Any matter urgent?
the matter. Like he wants some time.
Time, any matter urgent matter, very moderated today is to be accepted.
Any
date is there any interim?
No interim.
Whatever your blockman disposed of, that uncle nephew man.
No, not disposed of. It will come. It will come. Lordship, this matter may be Lordship will hard the matter. Only his reply is waiting.
Which one? This one?
Cut off date. Lordship. Only yesterday Lordship has had the matter. Only cut off date.
Oh, that one yesterday's matter.
Lordship has fixed this matter today for disposal. Only cut off.
We'll have it on Tuesday. Tuesday. The selected candidate on the date of consideration.
Yes.
I'll take only 15 to 20 minutes.
Have you found any decision?
Yes, the decision for consideration of the temporary appointment and the mild ad hoc appointment for the purpose of pension though, but it has been discussed that for all purpose of seniority and all these things, my lord, it can be considered, my lord. One judgment.
So what is the crucial date for assessing the quality or meeting the requirement eligibility? Number one, you can also argue on your experience.
Yes.
As an ad hoc company or whatever.
Yes.
That has been also settled by the Supreme Court. I have brought it up.
No. We do not even know who. Let's hope Tuesday this matter will come.